very much for being with me. It is early, just about 5:40 a.m. on this Friday morning, folks. But you are actually in my, I suppose, zone, because Towel likes to get up early. It's actually very hard for me to do these streams with you sometimes later at night. And although I think you can tell I'm able to do it, it's with usually an energy drink or in a state of near delirium once we get past 8 or 8:30 or so in the evening. But you get Towel in the morning like this, well, I have a lot to say. And I'm normally more in the zone, so perhaps this will be quite edifying and useful. The reason why I'm going live so early this morning is there is a 10 a.m. hearing in the Karen Reed and Aidan Kearney case, but we actually got a little preview of what's going to, I think, be discussed at that hearing, because the sum and substance of the hearing has to do with Aidan TurtleBoy Kearney's phones that were subject to search by the state in the context of his ongoing felony proceedings in the fall of 2024. And if you're just tuning in, my name's GrantSmithEllis, and there was one new filing. It went up last week on the docket, but it wasn't made public or made available, at least for my consumption, until last night, related to the contents of Aidan Kearney's phones, which we now know, per the court record, contain confirmed conversations between Karen Reed, David Yannetti, and Aidan Kearney, along with between David Yannetti and Aidan Kearney. And then at least by intermediary, who I think was Karen Reed, between Alan Jackson and Aidan Kearney. Now, we knew in previous court documents, in particular the affidavit, page 29 through 31 of the affidavit for the search warrant to search Karen Reed's cell phone in the fall of 2024, that there was extensive contact. I think 28 calls, at least between Aidan Kearney and David Yannetti directly, 28 calls between Alan Jackson and Aidan Kearney directly, and then 190 calls, 189 calls, and 40 hours, lasting at least 40 hours between Karen Reed and Aidan Kearney. But in this document, for the first time, we actually see enumerated what the nature of those contacts were. And we're going to hear even more at today's hearing, because today's whole hearing is whether Hank Brennan, pursuant to a pre-existing court order issued in the Karen Reed case, is able to, well, he has the material, but whether the scope of the material turned over from the search of Kearney's phone related to Karen Reed communicating with Aidan Kearney about tormenting witnesses in Reed's own case is going to be able to be used. If Brennan already has it. It was produced on Wednesday night of this week, subject to impoundment order to Brennan by the special prosecutor in Kearney's case, Robert Cosgrove. Now we're going to read a motion from Cosgrove hinting at just a little of the material, of the evidence that Brennan got on Wednesday, and it alone is explosive. And there is a statement in this motion that Karen Reed and Aidan Kearney are under active criminal investigation and could yet be indicted, or at least brought before a grand jury again, for conspiracy to intimidate witnesses in Reed's case. See what I mean? You all might be like, Grant, it is 5:40 in the morning. And I'm like, well, listen, if we could do these streams all the time at 5 in the morning, Tao would, I think, actually get a lot more sleep and be more well-rested. But yes, we're going to read through this motion, and then we're going to take a little bit of time as well to read through the full 22-page opinion from the First Circuit denying Reed's ill-fated federal appeal. By the time I went live yesterday, I was actually going live when the opinion dropped, so I only had the slip opinion when we were discussing yesterday, the one-page slip opinion. But I have the full 22-page opinion now from the Reed federal appeal. We'll read through that. It's really, really good. It just devastates any chance Reed had of delaying this trial due to that federal appeal. We'll talk about the implications of Hank Brennan's, or the 10 a.m. hearing today, and Hank Brennan's ability to use these messages from now confirmed, and I'm sure there's a lot more, between Kearney and Karen Reed, related to Brennan obtaining what's called a consciousness of guilt instruction during Reed's retrial, which one of the parameters for obtaining that consciousness of guilt instruction is witness intimidation. And if Brennan wins the motion, he can then present evidence vis-a-vis Kearney, who is on the state's witness list for the Reed retrial, in furtherance of that consciousness of guilt instruction. So it's not just presentation of the evidence during the case in chief, it's that the jury then gets told at the end of the case during their charging instruction that the evidence they heard related to witness intimidation is evidence of Karen's consciousness of guilt. But yes, so for that reason, we have to read a little bit about what's going on in the Kearney case. There are two things going on simultaneously in the Kearney case. we'll read the motion. The first one isn't as relevant to our purposes today, but it is important to understand because there were actually 6 phones seized from Kearney. 2 of the phones were fully indexed and searched pursuant to a warrant in November of 2024. The contents of those phones were what Brennan won related to Kearney's communications with Karen Reed last week. The 2 phones already subject to search. Now, unrelated to that, there are 4 other phones related to Kearney's ongoing felony proceedings in the Norfolk Superior Court related to witness intimidation of the Reed trial witnesses, along with allegations of wiretapping Lindsay Kearney and then submitting an edited copy of that recording into the court record, which attempted to splice the audio to show Kearney consenting to the recording when she didn't. But also witness intimidation of Kearney as well. The 4 phones in that other group that have not yet been searched are subject to a review by a taint team. Now, that taint team is a team that screens seized material for only attorney-client privilege material. Now, December 27, 2024 order was issued by Judge Peter B. Krupp in the Kearney case. Actually, 2 different orders. One was a protective order for Lindsay Kearney's cell phone that was inadvertently leaked by State Police Lieutenant Brian Tully, a full 15-year extraction, minus only messages that were deleted from the extraction while in State Police custody from Tully to Lindsay, and from Kate Mafia Masshole Peter, a self-proclaimed PI working for a guy who worked for a guy named Marty Kraft, who runs a PI firm that's definitely, in my opinion, in the orbit of some of the witnesses and officials in the Reed and Kearney cases. Judge Krupp issued 2 orders. One, the protective order for Lindsay's cell phone, and then 2, on that same day, December 27, 2024, Judge Krupp issued a taint team order for Aidan Kearney's 4 remaining cell phones. Now, this motion that Kearney had filed and that Special Prosecutor Cosgrove is responding to, it actually starts with an argument about whether Kearney should be able to expand the scope of material withheld from the taint team search, because Judge Krupp said that if Kearney identifies terms related to attorney-client privilege material, he can submit the terms to the taint team, who will review the material and screen based on the search terms. But the search terms have to kind of be approved by the court, and Kearney's trying to invoke reporter's privilege to expand the nature of the material the taint team will screen out from the prosecution to cover reporter's privilege material. But as we're going to find out from Special Prosecutor Cosgrove, reporter's privilege does not exist in Massachusetts. So the first part of the argument is not explosive. It's more why Special Prosecutor Cosgrove is saying this taint team for Kearney's 4 other phones should be able to move forward in line with Judge Krupp's pre-existing order, which is limited, which is very specific, and Kearney, the taint team will only do a limited screening for attorney-client privilege material, not reporter's privilege material. That's the first part of the argument. Then we get into the second part of the argument, where Special Prosecutor Cosgrove just drops this bombshell that he's starts revealing information, which he's allowed to do because the phones are searched, and he's making a court argument about Kearney's seized cell phones. And as you see on your screen, they literally detail evidence of contact between Kearney and Reed directly. So that means that's evidence on Kearney's phone showing direct contact between Kearney and Reed. And it's not just as like a record of like, oh, this number texted this number with no substance. There are actual contents of the messages, including Kearney and Reed talking about how Kearney is going to approach town employees, or if he knew about memos sent internally to the town about how town employees were supposed to respond to members of the media or someone like TurtleBoy approaching them. All of that is there. And then we find out even more down at the bottom, which is how David Yannetti was cheering TurtleBoy on and giving TurtleBoy the number of attorneys to help coordinate those attorneys going on YouTube panels. And then it does make you wonder, what are those 4 names that Yannetti back in 2023 was referring Kearney to? And was there some PR going on? But yes, we have a lot to read, and this is, as I mentioned, just a preview of what the 10 a.m. hearing is going to be about. Because remember, Kearney's argument at the 10 a.m. hearing is trying to limit Special Prosecutor Cosgrove has already turned over material to Hank Brennan for Brennan's use in Reed's trial. Kearney at 10 a.m. is going to try to go into court and say, no, Your Honor, what was turned over wasn't actually pursuant to the court order, and you should tell Brennan he can't use it. And clearly, we're seeing just a preview here. Cosgrove or Brennan is going to be able to say, Your Honor, these texts are directly within the scope of the order, and then I think they're going to start reading them and saying, Your Honor, here's some examples and more examples. That's what I think could happen. But yes, so this was filed, I think, last week, but it didn't actually get promulgated. I had meant to go in. It's so hard to get documents sometimes because you'll go in and they'll say, oh, we're going to email them out, and then they don't. But anyway, this one I had been meaning to get. I was able to, somebody, a very helpful account on Twitter, someone had posted in this terrible format on like this like scrollable like online site that was terrible. It was not a PDF. It wasn't accessible. It couldn't be read by OCR. So I went and found someone who had posted on Twitter, and then I recompiled all their images and I made it into a PDF. And if you check on my Twitter, you can get the link to the actual accessible OCR readable PDF. And that's what we're going to read. But it didn't actually come out till overnight. And please, for the love of God, folks, when you upload documents for accessibility reasons, please make sure they are in PDF format at the very least, because then at least if people who need to convert the text for screen readers can use them. If you just put up an inaccessible document on a Flipboard website, people who need to use speech to text can't use it, which is one of the biggest problems. On October 11th, okay, so here's the Commonwealth's opposition to defendant's proposal to compel screening of seized devices for purported reporter privilege material. Oh, people are actually awake. I had no idea some of you would join. I didn't expect many people to join. I was actually going to do this as a recorded video about the motion from Cosgrove confirming the contacts between Reed and Kearney and Reed's lawyers, and then the First Circuit full opinion. And I said, well, if I'm just going to do a recorded video, I may as well just go live, because that creates a recorded video at the end, and maybe some people in Europe or otherwise around the world will be up, or some night owls in America. So but this is morning for me. I get up around 3 or 4 a.m. every day, so I'm so glad. If you aren't able to see the evening shows, if you are joining today, I'm so glad you're able to be here. Maybe we'll see some new people. A lot of people watch over on the X, but as I try to do each day, I encourage folks to also watch on the YouTube. It doesn't really matter which one you watch on, but in terms of reading comments and answering questions, I can only really do that on the YouTube because the Twitter comments fade away too quickly for me to see them. So if you want to ask questions or engage, the YouTube's the way to do it. And I am trying to get this YouTube channel going. I don't stream that often on it, but if you want to subscribe from within the video or click like, that really apparently helps the channel. And yeah, I'll answer you don't have to send donations or super chats or anything. I don't do any of that. If you have questions or comments and they're not derogatory or discriminatory, I will read them. But yes, we're going to read through this motion. I'm just going to say, read some comments before we do. Cookie Ramlal says, hi, Grant. Great news so far. I checked it out on X. Yes, it is. This is definitely a bombshell motion. Marianne says, I'm so glad I caught you, Towel. Am I a washcloth? You are so smart. Yes, you can be an honorary washcloth. Maybe that's what we can call all of you. You are washcloths. But then, see, I do designate people honorary towels, and I don't want there to be a hierarchy. So I feel like washcloths and towels can be tantamount. It's not like becoming a towel is better than being a washcloth. If you're a washcloth, in my opinion, you're just as good as a towel. Busty DD says, go Grant. It's early, who cares? Cookie Ramlal says, wonder how Judge Cannoni is going to react to Karen's attorney. Oh, the new lawyer who was a juror. Yeah, that's going to be a ridiculous discussion. Marianne says, hi, roomies. Let's see. Marianne says, I hope Brennan does not let TB off easy. Yeah, well, if TB is going to claim the Fifth Amendment, Brennan has a tough decision about whether to give him immunity. I understand he needs TB to get KR, but TB was ruthless. I agree, but have you ever seen how immunity deals are structured? Most times it involves two criminals, both of whom are very ruthless. Need to plea one out to get the other. Grant, do you think this could affect law licenses? Yeah, I could see a lot of referrals to Bar Council. It's going to take like 2 years, but I could see this being a problem. What he said about Peggy was disgusting. Who? TurtleBoy? He says lots of things about Peggy. Mary Ninzio, honorary washcloths. Yes, you're all honorary washcloths. agree, Judd. Let's see, actually. We can... Here, now you're truly an honorary washcloth, Marianne. Just no abusing your privileges. People are allowed to speak as long as they're not discriminatory or offensive. Kelly Panton says, both of them disgust me and they both need to be in prison. Nobody is privileged enough to think they can be helpful and destroy people's lives. Yeah, I agree. All right, time to read. On October 11, 2023, the Commonwealth seized, pursuant to multiple search warrants, electronic devices from the defendant Aidan Kearney's home. The two were preliminarily searched under authorization and warrant. Thereafter, the defendant, through counsel, asserted that there was material on the devices subject to attorney-client privilege. The Commonwealth, therefore, agreed that it would not search those devices without first implementing a taint team procedure. See generally Preventative Medicine v. Commonwealth. Well, they kept referring to preventative medicine in court, and I was like, what preventative medicine are we applying? It's actually a case name. I thought it was like the doctrine of preventative medicine. Discussions with the defense followed as to appropriate members of the taint team, and Special Assistant District Attorney Kenneth Mello identified as expert Stephen Verano to extract the information from the electronic devices, and retired District Court Judge Joseph Macy to screen out protected attorney-client communications and confirm with them their willingness to serve in that capacity. For reasons previously litigated but not germane to the present discussion, the Commonwealth made no progress in advancing the search of the devices until August 12, 2024. Basically, someone was sick, and we know this because at public court hearings, the prosecutor was appearing with oxygen and stuff like that. So that's what Special Prosecutor Cosgrove saying. It was no one's fault on either side. Like, Kearney benefited from this delay, but it was no one. The state didn't want this delay. Kearney may have wanted it, but it was caused by the state, not due to any fault of their own, but because someone was sick. And the reason why it's not being litigated is because the judges in this case have already been very firm with Bradel that they're aware that one of the special prosecutors was very sick. It was not even. They didn't give Bradel, the judges gave Bradel no grace at all on that. They just immediately said the illness component was not a prejudicial issue or at all a problem because of the severity of the illness. So just so folks understand what's underlying that context there. If folks wondering, well, why did they take so long to review these devices? You know, they had them searched, and that's why. When it filed, so the Commonwealth filed with this court a motion for examination of the digital devices on August 12, 2024. So they had the devices in the fall of 2023. A lot of chaos occurs. They don't actually get the court order submitted to search them until August of 2024. The Commonwealth anticipated its motion would be heard on the next court date, but 5 Superior Court appearances followed considering intervening matters before this court reached the taint team question. So you see what's going on here? There's 2 phones that were subject to preliminary search. That material was done. That search was done in November of 2024. Then there's 4 other phones that were subject to this debate about a taint team starting in the fall of 2024 that have delayed their search. But there's 2 phones that are already searched. This motion is about the continuing search of the other 4, as I was explaining in the intro. And I can see now, upon reading some of this stuff back, why it's so inaccessible. Because it doesn't, like, just reading it on its face, you'd be like, okay, so why is this such a bombshell, and why is this, you know what I mean? You wouldn't immediately get the context. It's like, why they're arguing about phones that haven't even been searched yet. Why are we going to find out explosive information about Kearney and Karen's contacts on the phones that haven't been searched? And then you'll see how the argument evolves. It's basically like Cosgrove's using the argument in response about the other 4 phones to hook in. It's kind of like a speaking motion. Cosgrove is making a point to the public and to the judge, not only in the context of why Kearney's arguments are superfluous about trying to expand the scope of material that can't be reviewed by the Commonwealth pursuant to the taint team's screening, but then at the same time, Cosgrove's like, oh, and by the way, the reason why my argument's so strong is because I have evidence from the first 2 phones. Special Prosecutor Cosgrove, I don't know him, haven't spoken to him. I think I saw him a few times walking into court, but he's a former judge. And so Special Prosecutor Cosgrove knows exactly what he's doing here, and although he's building up to it, he used this motion as an opportunity for discerning eyes to see where this was going. Now, I don't think when Special Prosecutor Cosgrove filed this on the 20th, we even knew that this hearing was going to happen on Friday related to the scope of the material turned over by Cosgrove to Brennan. But now that we know this hearing's happening, and now that we're going to get to this document, through this document, this is a wonderful preview into the mind of the state as to what they're thinking about going into today's 10 a.m. hearing. Because remember, the hearing today isn't really about Kearney's motion or anything about the other 4 phones, although I think it might come up tangentially. The real issue, because it's an emergency hearing, I believe, is related to the scope of material that Brennan got from Cosgrove. And now we're going to quickly find out that this document is a hint that that material is very germane to Karen Reed and Aidan Kearney communicating for the purposes of potentially tormenting witnesses in Reed's criminal case. All right, here we go. On December 27, 2024, this court, Judge Krupp, issued an order establishing a taint team review procedure. In pertinent part, it provided that defense counsel file with the court a list of search terms to facilitate the taint team's identification of attorney-client privileged information. Order part page 2, section B. Emphasis supplied. The court, instead of saying added, former Judge Cosgrove says supplied. He is a very erudite writer, very old school writer. This is like someone who trained you. It's not just that his writing style is from like the 60s. It's like he was trained by people who wrote in like the late 1800s. I like it. The court specified certain terms, then allowed for additional search terms if necessary. However, if defendant offers additional search terms, he shall file an affidavit with the court affirming that they are necessary to identify and locate information protected by the attorney-client privilege, or otherwise explain why those supplied terms are necessary. The court provided that if the defendant believes supplying certain information required under the previous just described would compromise attorney-client confidentiality, he may submit such terms to the court under a protective order without disclosing them to the Commonwealth, including therewith a statement of good cause for each such term. Now listen, folks, I hope you remember Mark Betterow, Aidan Kearney's lawyer, one of them. He is admitted pro hoc vice from New York in Kearney's felony cases, but his pro hoc vice to join Karen Reed's defense was denied a month ago. And despite statements to the contrary by Aidan's Kearney's other lawyer, Tim Bradel, in open court, that there's some kind of joint defense operation or agreement between Kearney and Reed, there isn't one, and there is no attorney-client privilege for communications between Aidan Kearney, Alan Jackson, David Yannetti, etc., or Aidan Kearney and Karen Reed. And so, no reporter's privilege between Kearney and Reed, or Kearney and Jackson, or Kearney and Yannetti, and then no attorney-client privilege between Kearney and Jackson and Kearney, or Kearney and Yannetti. And that I think is why Kearney and Karen and all of their lawyers have been freaking out extensively over the past few weeks, because there really is some very bad stuff on those phones that Kearney has. And I will tell you, I have good reason to believe Kearney, years ago, when those phones were first searched, said it was the first 2 phones that he's most worried about. And those ones are already provisionally searched. We don't even have to wait for the taint team. And this motion makes clear we're going to start getting, the public is going to start getting the content of these phones. So it's actually good that Special Prosecutor Cosgrove lays it out this way, because we actually get a really good explanation of why the contacts. One, Kearney doesn't have a reporter's privilege, so everything in the phone except Kearney's discussions with his lawyers or legal team his legal team is going to come in. And you also have to remember, Kearney didn't actually get arrested until October of 2023, so he probably found out he was under investigation at some point, but a lot of this time, Kearney wasn't even charged with anything. So there's not going to be a lot of room to invoke attorney-client privilege. All right, argument. And also remember, this is only about the 4 phones that are not searched yet or being reviewed by the taint team. The 2 phones that are already searched, we're not even arguing about those. Kearney has to cede to the state and to the judge. Yeah, those phones are already searched, etc. So the only thing Kearney can argue about that is whether the content of the 2 phones that were ordered to be turned over to Brennan under a court order by a judge in the Reed case related to Kearney's communications with Reed about three specific subsets of topics: tormenting witnesses, communicating with family of witnesses or witnesses in the Reed case, or videos of or dissemination of attempts to intimidate witnesses. Though all those discussions, and that's already in. Kearney can't even argue that. The only thing Kearney's going to be able to try to argue today, and he's going to fail miserably, it's going to be quick and it's going to end, it's going to be brutal. We might hear some of the messages, but it's going to be a quick decision, which is the material turned over by Cosgrove to Brennan is in line with the court order. Brennan may use it for his purposes, and then we'll see a consciousness of guilt motion from Brennan in the Reed case basically immediately. So this is Kearney's last ditch. That's why we're doing this, I think, on a Friday at 10 in the morning. Kearney's not even going into court. He's going on Zoom. It's going to be brutal. It is going to be a humiliation ritual, basically, for Aidan Kearney, a juridical, by analogy, humiliation ritual, because there's no merit, there's nothing to argue. The phones are already turned over. The two phones are already searched. The communications between Reed and Kearney are already starting to come out there in these motions. So all Kearney's posturing about there's nothing on there, et cetera, he's wrong. Clearly he's wrong. And then the judge is just going to say, okay, Mr. Brennan, you can use the material turned over to you by Mr. Cosgrove. And then the judge might say, Mr. Kearney, there's no reporter's privilege, but you can continue to submit for the other four phones any attorney-client privilege search terms and you want the court to review, but I'll give you 14 days or whatever, and then the taint team is moving forward. Because that's really the question. Until Kearney finishes up this compliance with screening of the proposed terms to screen out the taint team needs to screen out, the taint team can't turn the material over to the state. So it's more delay. So on that issue, maybe the judge will say, all right, Kearney, you have 14 days, submit some new search terms, but then this taint team's going forward. But on the separate bifurcated issue of the first two phones and their content being turned over to Hank Brennan in the Reed case by virtue of the prior order of a judge to Cosgrove requiring subset categories of information to be turned over therefrom, no chance. There's no argument. It's over. There isn't going to be an argument. It's going to be a very weak, oh, Your Honor, Cosgrove turned over stuff that's outside the scope of the order, and Your Honor's going to say, I read the material. I know what the order says. You're wrong. And that's going to be the end of it. But let's find out why it's devastating. Let's get a little bit more into the background here about why Kearney's futile attempts to invoke reporter's privilege are just going to fall flat. As a general rule, the question of reporter's privilege arises in the context of reporters subpoenaed or summoned to testify. The lead federal case is Brazenberg v. Hayes. Therein, Brazenberg, as well as a New York Times reporter, I wonder if that was a Pentagon Papers case, and a Massachusetts television reporter, Pappas, were subpoenaed before separate grand juries in order to name the sources of their articles. They refused and were held in contempt. This is a great footnote. Thank you, former Judge Cosgrove. I appreciate someone who takes the time to write a historical treatise within a motion. That is the type of thing that towels appreciate. Elevates Prosecutor Cosgrove to the status of honorary towel. But again, honorary towels and honorary washcloths are on similar planes. There's no hierarchy in the towel universe. White's opinions as I go into reading a SCOTUS decision. White's opinion describes the history of the Massachusetts case as follows. Before the grand jury, Pappas claimed that the First Amendment afforded him a privilege to protect confidential sources, confidential information, informants in their information. Brazenberg v. Hayes. Served a second summons, Pappas moved to quash on First Amendment grounds. The motion was denied by the trial judge who, noting the absence of a statutory newsman's privilege in Massachusetts, ruled that petitioner had no constitutional privilege to refuse to divulge to the grand jury what he had seen and heard, including the identity of persons he had observed. The Supreme Judicial Court, quote, reaffirmed prior Massachusetts holding that testimony or privileges were exceptional and limited, stating that the principle that the public has a right to every man's evidence had usually been preferred in the Commonwealth to countervailing interest. The court adhered to the view that there exists no constitutional newsman's privilege, either qualified or absolute, to refuse to appear and testify before a court or grand jury. Any adverse effect upon the free dissemination of news by virtue of petitioners being called to testify was deemed to be only indirect, theoretical, and uncertain. The court concluded that the obligation to newsmen is that of every citizen to appear when summoned with relevant written or other material when required and to answer relevant and reasonable inquiries. The court nevertheless noted that grand juries were subject to supervision by the presiding judge, who had the duty to prevent oppressive, unnecessary, irrelevant, and other improper inquiry and investigation, to ensure that a witness's Fifth Amendment rights were not infringed, and to assess the propriety, necessity, and pertinence of the probable testimony to the investigation in progress. The burden was deemed to be on the witness to establish the impropriety of the summons or the questions asked. The denial of the motion to quash was affirmed. Is there any more to this footnote? No. Okay. So yeah, very good history there. I appreciate that. You're not quashing a subpoena if you're a reporter. You might be able to invoke the Fifth, but you can also get that taken away if you're given a limited grant of immunity. You might be able to invoke attorney-client privilege, doctor-patient privilege, priest-penitent privilege, but you can't invoke reporter's privilege. Too bad, Aidan. You should have became a priest, I guess. Writing for the court, Justice Byron White declined to find in the press clause of the First Amendment, quote, a testimonial privilege for newsmen that other citizens do not enjoy. However, White noted favorably a previously established test, so that's dicta, requiring the government to convincingly show a substantial relation between the information sought and a subject of overriding and compelling state interest. So it's kind of like the test if you want to call like a DA. You could do it, but you need to show you can't get the information, or like a president. You like subpoena a president. You can't get the information in other ways, and you have to show a substantial relation and a compelling state interest. And the reason why is, if you think about it, that's a analysis under the 14th Amendment. It's a strict scrutiny analysis. So it's as enumerated by the 14th Amendment. The First Amendment's due process clause puts certain requirements on state actors, and one of them is if a state actor wants to do something that imposes on speech rights, either enumerated or implicit, then that state actor has to meet a test that involves balancing a compelling state interest against the First Amendment. And so here you can see that that's what White's saying. You can ask a reporter to testify. They can assert a privilege, but at a bare minimum, because of the First Amendment implications, you have to show a compelling state interest. And basically any criminal investigation is a compelling state interest. Thereunder, the judge should examine the reporter's claim on its facts by striking the proper balance between freedom of the press and the obligation of all citizens to give relevant testimony with respect to criminal conduct. And that was a concurrence by Justice Powell. Subsequent federal cases have attempted to apply Brasenberg, but have ranged widely in their interpretation of it. See McKevin v. Polish and cases there cited. Massachusetts, likewise, has not legislated. So basically the point is, although cases have interpreted Brasenberg differently, the foundational principle is there's no reporter's privilege, and the basic test, and it doesn't even require strict scrutiny, but if you really want to go above and beyond, apply a strict scrutiny balancing test, look for a compelling state interest, and if it's there, then not only is there no reporter's privilege, but then the subpoena is validly issued. Massachusetts, so it's more about, can the moving party who wants to compel a reporter like Kearney to testify show a compelling need, and it's obvious if they're the state they can, but show a compelling need. Once you do that, there's no argument. It's all about form. There's no argument about sum and substance of the privilege. There's no reporter's privilege. It's just a regular Lampron analysis, basically, and Brennan already won the motion under Lampron. If we're talking about, this is Special Prosecutor Cosgrove here talking a little bit more broadly about Kearney invoking reporter's privilege for the 4 other phones that are still subject to taint team review. But if we're extending this and we're thinking about how it applies to Brennan as well, using this material, Kearney can't invoke any reporter's privilege. There's just absolutely foundationally, federally and on the state level, no reporter's privilege. The only way you can object to this kind of subpoena to testify or for evidence is under an analogous test to Lampron, which is a Rule 17 motion for records, third-party records. And in this case, Brennan already filed the Lampron motion and won that motion easily. So that's why and Cosgrove, I think, is going to easily get access to more content from these other 4 phones as well. Although, as I mentioned, I think it's the content of the first 2 that Kearney's most concerned with. But Kearney can, I'm trying to say, Kearney can raise First Amendment issues, reporter's privilege issues, whatever, to try to quash his subpoena to testify in the Reed case as well. The same argument he's trying here, and it's not going to work either. for exactly this reason that Special Prosecutor Cosgrove is laying out. Massachusetts, likewise, has not legislatively adopted a reporter's shield law. Bills establishing a reporter's shield law have repeatedly been filed in the legislature and have uniformly died there without passage. It's much easier to kill a bill than it is to get one passed. See appendix for 3 examples of such bills. Nice! Special Prosecutor Cosgrove was doing some shepherdizing into the history of failed efforts to establish and codify a reporter's privilege in Massachusetts. With respect to search warrants, the legislature has provided that no search and seizure warrant without a warrant shall be conducted, and no search warrant shall issue for any documentary evidence in the possession of a lawyer, psychotherapist, or a clergyman who is known or may reasonably be assumed to have a relationship with any other person with which relationship is subject of a testimonial privilege subject to certain qualifications. GLC 276-6. Notice, and I noticed it, pointedly absent from the list of shielded parties is journalist or reporter, lawyer, psychotherapist, clergyman. The Supreme Judicial Court has hewed to a inclined to a common law approach consistent with that suggested in Brazenberg. Quoting the SJC, before ordering a reporter to divulge a source in the information gathered, a judge must consider the effects of compelled disclosure on values underlying the First Amendment and art. See what I'm saying here? It's a First Amendment balancing test. Citing petition for the promulgation of rules, so it's Mass Guide to Evidence, page 92, section F, paragraph 4. Citing petition for the promulgation of rules regarding protection of confidential news sources and other unpublished information. 395 Mass 164, 1985. Rejecting request of the Governor's Press Shield Task Force that the court adopt rules providing for a qualified evidentiary privilege to protect news reporters and others from the forced disclosure of confidential sources and unpublished information. Yikes. Accordingly, a judge must balance, that's bad for Kearney. Accordingly, a judge must and for Gretchen Voss. Accordingly, a judge must balance the public interest in the use of every person's evidence against the public interest in protecting the free flow of information. Citing matter of a John Doe grand jury investigation, 410 Mass 596, 599, 1991. Considering the Brazenberg type analysis set forth by the SJC, the defendant's position is considerably worse than that of Pappas, the reporter in Brazenberg. First, he is not being compelled to divulge anything. Rather, any information discovered will flow without his compelled cooperation, being acquired by a lawful search warrant. Yeah, he doesn't. It's already searched. He's not being asked to testify about it yet. Second, he is not a disinterested reporter merely seeking to protect confidential sources. Rather, he is a defendant in a criminal case seeking to conceal information that may be damaging to him. Oh, damn. Let's read footnote 2. For the purposes of the present motion, the Commonwealth does not dispute that the defendant is a reporter. Judicial creation of a reporter's privilege, however, would present practical and conceptual difficulties of a high order. Sooner or later, it would be necessary to define those categories of newsmen who qualified for the privilege, a questionable procedure in light of the traditional doctrine that liberty of the press is the right of the lonely pamphleteer who uses carbon paper or mimeograph just as much as the large metropolitan publisher who uses the latest photocomposition methods. Freedom of the press is a fundamental personal right which is not confined to newspapers and periodicals, but comprehends every sort of publication which accords a vehicle of information and opinion. Oh, I'm well aware. Third, just as the SJC and the U.S. Supreme Court had little difficulty in concluding that a legitimate grand jury inquiry qualified as a compelling state interest requiring reporter Pappas, like any other citizen, there we go, that was the point, a grand jury, a criminal inquiry is a compelling state interest, to appear and testify as to his sources, this court should have no difficulty including that the Commonwealth's interest in executing a lawful search warrant, particularly against a defendant who is the subject of multiple indictments for intimidation of a witness, a crime that strikes at the heart of the judicial process, far outweighs any abstract, quote, public interest in protecting the free flow of information. And Special Prosecutor Cosgrove is on the money there. There's no differentiation between Brazenberg's analysis and the analysis here. It's actually way less pernicious or insidious than Brazenberg being compelled or Chelsea Manning being compelled or anyone being compelled to testify before a grand jury. These are evidence searched and seized already from the 2 phones and the other 4 phones pursuant to valid warrants. In fact, the judicial finding of probable cause for the search warrant by a justice of this court should be dispositive in that respect. Literally, I was thinking that. I haven't read this in full yet. I was thinking it's the issuance of the search warrant where Kearney could have fought this, but he could have tried to quash it, but the search warrant issued based on probable cause. So there is no... That is the highest level of compelling state interest. It's not just you're being investigated by the police. Sorry. Oh, definitely heading towards spring. It's not just that you're being investigated by the police in this case. It's that there was a judicial search warrant. That is the highest possible compelling state interest. Further, the affidavit, and dispositive just means it goes to prove Special Prosecutor Cosgrove's point. Further, the affidavit in support of the warrant alleges inter alia that there is probable cause to believe that the data within the electronic device will contain evidence of conspiracy. If indeed sources provided the defendant with information knowing that he intended to use the information to intimidate witnesses in a criminal case, that is evidence of criminal activity by both Kearney and the source. Okay, all right. Listen. Do you all understand the implications of that sentence? I read it at first and I understood it because it gets referenced again, the possibility of Kearney and Karen being under investigation. But this has wider implications. If Special Prosecutor Cosgrove or Special Prosecutor Brennan can prove, based on the enumeration just laid out there under the case law, that Kearney was given information by Reed's lawyers and they had knowledge he was going to use it to commit a crime, that can pierce their attorney-client privilege with Karen because it brings up the crime fraud exception to the attorney-client privilege rule, but also it could induce criminal liability for Karen, Yannetti, and Jackson. I'm really starting to wonder if they're going to indict Alan Jackson or David Yannetti. You can do it. I've seen a lawyer in Nevada, Bradley Balsario or something, get criminally charged. And there's nothing that, thanks to our Nevada judges on YouTube, by the way, they do great chronicling of the Nevada court system. Watched every single bit of the Ken Blandino trial. That's why I know about the Nevada court system. And I know a lot about the case related to where you can have your right to counsel. You can have your right to represent yourself taken away, and you can have counsel forced upon you. It's some case from the 80s. But yes. What was I? Oh, I was talking about how we may have the potential for actual criminal liability for not just Karen Reed, but maybe Yannetti and Jackson as well. And that sentence is very nuanced. But that sentence could directly, based on what we're going to read next, be a precursor to Special Prosecutor Cosgrove saying he has evidence of criminal conduct between all of these parties. All right, so on that note, I'm going to pause and read some comments. Oh, a lot of you are joining. Good morning, everyone. I'm glad you all are waking up. The reason I'm doing the stream so early is there's a 10 a.m. hearing in the Reed and Kearney case, which isn't going to be that long because fundamentally Kearney has no grounds to really make any arguments. The sum and substance of today's hearing is the material that was turned over by Special Prosecutor Cosgrove to Hank Brennan for Brennan's use in the Karen Reed retrial for the purposes of obtaining a consciousness of guilt instruction by way of witness intimidation under a theory of joint venture as enumerated by Commonwealth v. Mahoney in footnote 2 of the reporter's note to the witness intimidation and consciousness of guilt jury instruction. Can Brennan use the material that was already turned over by Cosgrove on Wednesday night, which Brennan and the Reed defense and the judge in the case have reviewed? And is that material that was turned over within the scope of the order that Brennan won last week pursuant to Rule 17 and Lampron for access to that material from Special Prosecutor Cosgrove, who is in possession of these search phones that were subject to review in November of 2024, 2 of Kearney's phones, and thus that is what today is going to be about. We are reading a larger motion about 4 other phones that Kearney has and whether the state should be able to continue to search them and whether Kearney can assert some kind of reporter's privilege. But nested within that argument is this brilliant insight about what we might find out about today or next week or whenever we find out about more about the content of Kearney's phones and his communications with Karen Reed, David Yannetti, and Alan Jackson. Because in this motion, and we're about to get to it, as you can see now why, Special Prosecutor Cosgrove has laid the hook here to say, look at this. It's not just that Kearney was communicating with confidential sources. We have reason to believe that those communications with Reed and others were done in the context of those sources knowing Kearney was going to use the material to commit a crime. That's bombshell. And we are going to see exactly why in a second. Let me see. Oh, Trevor McIntyre is with us. Oh, a lot of you are with us. Hello. I didn't realize so many of you had joined. Let's see. Hold on one second. Good morning, Trevor. So nice to see you. You're now a washcloth. Good morning, Jew Drops. Justice for John O'Keefe and his family. I agree. Thank God Dewdrop says, thank God we have Hank, the special one. I agree. Goldie Lawrence says, good morning, friend. Are they going before the same judge? I don't know who we're going before today, but that judge gave Hank Brennan one hell of a victory last time. Good morning, Judge Cannoni. I don't think it will be Judge Cannoni today. Let's see. Prosecutor Brennan should get all the incriminating messages just to show the real bully in Reed. Oh, he will. TurtleBoy is going to become Karen Reed's albatross. Thank God Mass does not see him with a special privilege for being a reporter. Yeah, no special. Him or Voss, neither. Gretchen Voss is going to get called too. Let's see. Trevor McIntyre says, why does Brennan even need a Rule 17? If it's possession of the state and it's relevant, how does Aidan have standing? The witnesses in federal grand jury didn't have standing to object to their material. Yeah, so this came up actually. Hold on one second. It came up in the ruling. I was just reading it yesterday. It came up in the full ruling from when Kearney initially lost initially lost the motion to prevent Brennan from getting access to this material. So let me see if I can bring this one up for you. I know I had it yesterday. Let me just see if I can get the actual full document. Nope, that's the motion to dismiss. But Trevor McIntyre, you bring up a really good point, because the ruling from the judge for in Kearney's case definitely had a direct reference to how Brennan said he mentioned that he didn't need to use Rule 17, but was doing it to the court, out of deference to the court, and the court noted it and said it wasn't going to reach that argument from Brennan, and it was just going to assume that it was the court was just going to assume that it was made under a Rule 17 finding. But what I'm trying to do now is actually get the full motion, so give me 1 second. I know I have it somewhere. I think it was because initially I didn't actually get the full ruling. I had just brought up part of it. But no, I'm not going to get distracted on this point. But your point here, Trevor, is absolutely right, which is that Brennan didn't need a Rule 17. He went above and beyond, filed the Rule 17, and won. But yes, you're right. The judge did make note of that and didn't actually reach the issue. So that's unsettled right now. Whether in this case, where there's a special prosecutor, in Kearney's case, the Rule 17, because the material is in the care, custody, and control of the state, even needed to be subject to a Rule 17 order. But with the T's crossed and the I's dotted, Brennan got the order under Rule 17 in Lampron, and thus it's a moot issue anyway. Let's see. I don't think Judge Cannoni is going to allow the third-party culprit, no. Cookie Ramlaw says, Marianne Nunzio, we have to laugh through all this ridiculous attorney and their arguments. It's why I like Grant so much. Well, I am a towel. Let's see. We must keep praying for justice. Yes, I agree. Always pray for justice. Cookie Cosgrove rocks. I love his writing style. Me too. Sources KR attorneys and KR. Yep. Grant, do you think her lawyers will show up with their own lawyers at some point soon? Yes. I don't know about today, but they're going to be subject to disciplinary proceedings. We can only hope they go after Jackson and Yannetti. They need to be disbarred, in my opinion, at least reviewed. Towell is pretty brilliant. How old is he? I am 36. Oh, that's very kind to say I'm brilliant. I definitely do better in the morning. I don't know if you can tell. Like, I am okay at night. I can spin a yarn and do some pretty good syntactical, dialectical maneuvering and paint a pretty good historical mosaic as an active application of my larger moral, socio-political framework or whatnot. But in the morning, I am far more erudite, way more analytical. This is where I really thrive. So maybe I'll do some more morning streams. I didn't know so many of you are awake this early in the morning with me. So, Goldie says, thank you, Grant. Christina says, good morning. Busty Dee says, what do you think of the ex-juror now working for DY? Oh, it's a huge problem. It's an ethical bombshell. It's an unprecedented move never seen before in the history of the United States. I've consulted with a number of different experts in this field. We've done an extensive number of searches. We can find no case, and it's a diagnosis of exclusion, but we can find no case in the history of the United States where a juror lawyer from a previous mistrial has ever joined a defense upon retrial. Upon review of a secondary source that was actually quite excellent, and kudos to Kerry Gold for finding it the other day. There are examples that popped up originally in 1985 in Connecticut and then reemerged in 1999 in Florida and 2001 in California, where previous jurors from a mistrial were brought on as consultants for a defense retrial. Now, that itself was an ethical quandary that was discussed extensively in law reviews right around 2004, 2005, I would say, is the epitome of when the apex of when this discussion was occurring. It never went beyond that, and there is certainly no scholarship that I can find, nor any case law of any kind anywhere, about a former juror lawyer from a mistrial joining a defense team for the retrial. Unheard of. I don't even know what to make of it. It's unprecedented. It doesn't exist. But okay, so we are. I got caught up on questions and comments. Now we're almost to the explosive part. But all this foundation has been quite important. Taint team analysis has been and must continue to be limited to protecting attorney-client privilege. This is just further background, but it's important for why attorney-client privilege is the only thing that Kearney can assert. We're talking about the other 4 phones, by the way, now, folks. This is the last part of this motion that's not relevant to the 2 phones and the material that's going to come up at 10 a.m. today. Preventative medicine v. Commonwealth, 465 Mass. 810-213, affirmed that proper use of a taint team adequately protects a defendant's Sixth Amendment rights, as well as his Article 12 rights under the Massachusetts Declaration of Rights. It says nothing about protecting any other privilege than the attorney-client privilege, and notably, every case cited by the Preventative Medicine Court deals with attorney-client privilege. Preventative medicine broke new ground only in that it dealt with protecting attorney-client privilege in the context of searching electronic devices. It has long been the practice to afford such protections in searches of physical documents. A law office search should be executed with special care to avoid unnecessary intrusion on attorney-client communications. A taint team represents one possible example of special care afforded attorney-client privilege in the context of searching electronic communications. While special care procedures are routinely employed when there is a reasonable possibility that attorney-client privilege material may be unearthed during a physical search, no such procedures are routinely employed as to other potential confidential and privileged information. Rather, if such material comes to light, the remedy, if any, is simply a motion to suppress or motion in limine as appropriate. The same should be true of electronic searches. The defendant has argued that the logic of preventative medicine should apply to other privileges, such as the so-called reporter's privilege. First, as set forth above, good thing that we read it, Massachusetts does not recognize a reporter's privilege, and that in itself, oh, that's how you say it. That in itself should end the discussion. I agree. Second, whatever limited judicial protection is afforded reporters confidential information under a Brasenberg-type test, so if there is a balancing test, first of all, the burden's on Kearney to assert it, and second of all, the Commonwealth can easily rebut by showing a compelling state interest. A Brasenberg test must yield to the Commonwealth's compelling state interest in executing a valid search warrant in a criminal investigation. As also set forth above, and given that reality, it is pointless to screen out purported confidential source information, as the Commonwealth's valid interest will not vary based on a piece-by-piece examination of the confidential source results. Exactly. If it's not attorney-client privilege, every single balancing act will be, this was a valid warrant, compelling state interest pursuant to an active criminal investigation signed by a judge. Compelling state interest, compelling state interest, compelling state interest, compelling state interest. So you can just make a universal ruling on every invocation of the protection that every single disclosure is justified by a compelling state interest. Thus, there is no reporter's privilege. Third, there are a great variety of situations in which a confidential relationship between parties that merit some protection. Third, there are a great variety of situations in which there is a confidential relationship between parties that merit some protection, even if it falls short of a privilege. 3. For an extensive list, see Mass Guide to Evidence, 2019, pages 92 to 96, Article 5, Privileges and Disqualifications. To expand the taint team's search to include anything related to the entire gamut of privileges, almost all of them, unlike the attorney-client privilege capable of being pierced under appropriate conditions, would subvert the normal process of search pursuant to warrant and enmesh the special master in time-wasting, I think that should be a 1 dash, not 2, and ultimately unproductive activity. There is no case law countenancing any such procedure. So then the other argument here is the court order underlying the search of Kearney's 4 more phones and the taint team review thereof says attorney-client material, not all these other privileges. And in fact, you can't assert privilege in the context of a search under all those other privileges. That's a completely different thing. Conclusion. Oh, this is where it gets really good. I hope you're ready for this. Just tucked into the conclusion. That's how if you really are saying something explosive in emotion, you don't lead with it. You nestle it in there. The subtlety is the art of emphasis. It's like a good jazz song. The absence of noise and cacophony is what you're looking for to understand the rhythmic undertones, and that's exactly what a good motion is like. I guess in some ways jazz is a commentary on good literature in that way. It's what's not said or what's understated that can make the largest point to a discerning reader. It's a good juxtaposition with the surface level vacuity that you see with bloviating based PR motions or legal campaigns. They always lead with some premise that sounds explosive but is fundamentally vacuous. When you have a really explosive piece of information, you lead with a lot of dense, unrelated material, though it all is related if you're paying attention, and then you just drop the explosive stuff. You know it's important. People who are reading will know it's important. It's important to the way the process will play out. You don't need to scream it from the rooftops. If anything, that's kind of profane and an insult to the intelligence of a discerning reader or listener to do that, and that's why this next paragraph is so sublime. We'll make a statue of Hank Brennan, Ken Mello, and Robert Cosgrove. You got to throw Lally on there, and Laura McLaughlin, and the woman who helped with presenting the exhibits on the screen, and the court reporter, Madam Court Reporter. It was a little weird though, like some of the way the online trolls like picked up on Madam Court Reporter. That became really uncomfortable. They became like fixated on her. I would like joke about it every once in a while, but some of them like made accounts about her. It was really weird. Anyway, conclusion, summary, and requested relief. Judge Krupp's order authorizing a taint team procedure provides only for screening for attorney-client privilege material, as set forth above. Neither the United States Supreme Court nor the SJC recognize constitutional reporter's privilege, and the SJC has refused to adapt, and the Massachusetts legislature has refused to adopt a rule recognizing a limited reporter's privilege. Under the case-by-case analysis embraced by the SJC, the Commonwealth's interest in investigating and prosecuting a criminal case easily outweighs the reporter's compelling interest. Additionally, the Commonwealth is aware of no case, federal or state, in which a taint team procedure has been employed for anything other than attorney-client privilege information. This court should deny the defendant's meritless request to apply to a reporter's privilege in the case at bar. This court's taint team order provides that after the court's review of the search terms filed in compliance with Section B of this order, the clerk shall transmit the information to the forensic examiner, noting information that must remain confidential. Order, page 3, C1. That review should logically consist of determining whether the defendant submitted the court's designated search terms under its order. The court should then check to see whether the defendant has submitted additional search terms under B1B. If Kearney has, the court should check to see if Kearney, in conformance with the court's order, filed an affidavit with the court affirming that the supplied terms are necessary to identify and locate information protected by attorney-client privilege, or otherwise explaining why those supplied terms are necessary. If the defendant has submitted additional terms but has not filed the appropriate accompanying affidavit, the court should strike the additional terms, or at the very least order the defendant to show cause why they should not be stricken. If the defendant has filed the accompanying affidavit, the court should determine which of those terms, if any, are appropriate, and then direct the clerk to convey the court-approved terms list to the taint team. So basically, Cosgrove is saying Kearney can submit all these requests to screen out all these search terms from the material that he wants, but if it's not in line with the court order, the court should strike the request and then order the taint team not to consider those parts of Kearney's request. Which is exactly what the judge is going to do. And then this is where it gets good. Just hiding in there. The Commonwealth takes this opportunity to renew its argument previously brought to the attention of the court that under no circumstances should there be search terms designated to screen out communications with Karen Reid's attorneys, including but not limited to Attorney Jackson and Attorney Yannetti. Commonwealth Revised Proposal for Exam of Digital Material, page 5, number 3. The defense has previously objected to the Commonwealth's position, but has conceded that Reid's attorneys have not and do not represent Mr. Kearney, but suggesting there is a joint defense. 4. According to Mr. Bradle, there is no agreement for a joint defense, but an alleged ongoing long-term implicit mutual assistance and mutual defense. Whatever the present merits of that argument, and note, Mark Betterow was denied his ability to join Karen Reid's legal team. Betterow is one of Kearney's lawyers. Whatever the present merits of that argument, as Judge Krupp correctly noted, all the devices at issue were seized before Mr. Kearney was charged and before he knew he would be charged, so nothing within them could be covered by the alleged joint defense. There you go. I knew it. Since Kearney doesn't even have an attorney-client privilege with Reid because he didn't even know. And he didn't retain David Yannetti and Alan Jackson. And Alan Jackson and David Yannetti, I think, have said that there's no joint defense in open court in the Reid case. Here we go. Since raising its objection to inclusion of terms designated to screen out communications with Reid's defense attorneys on November 30th, 2024, undersigned counsel has reviewed some of the data from one of 2 cell phones lawfully searched pursuant to warrant prior to any defense request for a taint team. Oh my God. Cosgrove only has reviewed 1. Brennan's definitely going to get even more. Oh, whoa. Well, actually, let me pause. This was March 20th. So it's very possible that this motion was filed before Cosgrove finished going through both devices, and then he submitted a status report, which is under impoundment, on Wednesday, which was the 25th, Tuesday or Wednesday night, 24th, 25th. Oh, my dear God. Oh, my dear God. This is only just an initial summary of 1 phone. Oh, I hope that if the judge today can choose to lift the provisional impoundment on Cosgrove's status report and potentially the evidence therefrom, if we can get this status report, folks, I'm telling you, this could be the day. I think Hank Brennan, Bob Cosgrove, Ken Mello, I think they all just struck fucking gold. I think today's the fucking day. Just from what was revealed from one of the 2 phones, this is an indicator that they have it. They got them. I don't know what they're going to do with all of this information, the state, but this is it. I don't think this is going to be, as I said, a long hearing today. I think it's just going to be confirmation, and hopefully the documents get unimpounded, that the material from both of those phones is extremely fucking damning and confirms everything that people have suspected related to the relationship and communication between Karen Reid and Aidan Kearney. Now, mind you, there were leaked group chats in May of 2024, which you can see. I've detailed them under the Karen Reid trial leaks coverage on my feeds. You can see the leaked messages from Aidan Kearney where Aidan is saying things like, talking to Nick Rocco and Jenna Rocco, and Aidan is saying, who do you think told me, quote unquote, Aidan Kearney, to run Jen McCabe's license plates? He's implying it was Karen Reid. And then Kearney says, who do you think told me to ask Karen Reid, ask Jen McCabe at a children's lacrosse game, did you really think you could outsmart Karen Reid? Implying it was Karen Reid. And he said those in group chats in May of 2024, which are documented on the record that got leaked. And I hope you all are picking up on the implications here, which is that although we're going to see what was discussed in the first phone, which is damning enough because it blatantly, directly contradicts Kearney's statements over the past week that there's nothing on his phone showing communications with Karen Reed. Now we know that there are, and this was just one fucking phone. Oh my God! I read this when I woke up this morning because the document came out at like midnight or something, and I read this. And I got the implications of it, obviously, but the one thing I missed was that he had at the time on March 20th, Cosgrove had only reviewed some data from one of two phones. Oh, wow, folks. Well, I hope you're glad you're watching, because you really had to parse through to find that little nugget of information. And I'm telling you, whether it plays out today, because again, today's hearing is more about whether the material turned over to Brennan is in line with the judge's order as to what Cosgrove could turn over from Kearney's phone. Once we get through that, which is going to be very quick, the only question is the impoundment order going to lift? Can we all see this material? It's already being referenced partially in some of these motions. Oh boy. The partial phone contents from just one of the phone strengthen the Commonwealth's argument here. Kearney's phone contains text messages between not only Kearney and Karen Reed, but the defendant and attorney Yannetti. Actually, I'm going to read this paragraph one more time because I'm going to record this part. Since raising its objection to the inclusions of terms designated to screen out communications with Reed's defense attorneys on November 30th, 2024, undersigned counsel has reviewed some of the data from one of the two cell phones lawfully searched pursuant to warrant prior to any request from Kearney's defense for a taint team. My word. As I just said, that sentence is explosive. As of March 20th, okay, when this motion response was filed, the special prosecutor in Aidan Kearney's case had only reviewed partial contents of one of two cell phones from Kearney. As of March 25th, there was a full status report on both phones filed with the court, including USB drives and evidence that is now in Hank Brennan's possession and subject to provisional impoundment. Today's 10 a.m. hearing, in turn, is simply perfunctory and pro forma and will only confirm that the material handed over by Cosgrove, which is more expansive than we're about to read about, and trust me, this is explosive in itself, is going to be confirmed as within the scope of the court's order. Once that happens, that's it. It's over. There's nothing else to argue. We may even start hearing more and more about the contents of these phones, either at oral argument today, maybe in a motion filed by Brennan for a consciousness of guilt in Reed's case. It's coming, folks. It's coming. I can sense it. I can feel it. I can feel it like a impending rainstorm. The contents of those phones strengthen the Commonwealth's argument here. Just the one phone, the partial one phone. Kearney's phone contains text messages between not only Kearney and Karen Reed, but the defendant and attorneys Yannetti and Jackson as well. The text exchanges also make clear that the Reed team was in telephonic and email communication with the same people. The Reed team repeatedly provided Kearney with information, including videos and copies of documents, sometimes with a request, always acceded to. That means they had editorial control over what he was doing, that he not use it or not use it yet, lest the Commonwealth discern its source. At times, Reed's team would suggest angles for Kearney to cover or otherwise ask for his assistance. For example, on 8/8/23, Reed texted Kearney. Oh my God, they have direct text from Reed to Kearney. Reed texted Kearney, "Do you have the memo town employees in Canton were emailed about speaking to you reporters? Alan wants to blast it." The Reed team responded to Kearney's specific requests for information, discussed strategy, and quite frequently stoked his ego by effusing about his YouTube presentations. Oh, let's read this footnote. Oh, God. Here are some representative examples from attorney Yannetti. On April 22nd, 2023, Yannetti texts Kearney, "That was priceless, dude. Great fucking show. Really enjoying the turtle reporting." On 5/29/2023, just a typo there, Yannetti assured Kearney, "You are a class act. Karen and her parents thank you. Oh, Yannetti was acting as an intermediary. Oh, that's even worse. A few weeks later, on 6/9/2023, Yannetti texted another great article by TB. You are doing God's work. Oh, that's gross, David. Told by Kearney on 6/9/2023 that on July 25, Kearney will hold a protest on the courthouse steps where he will have a megaphone this time and make sure hundreds of people are there. Yannetti responded that he loved it. Oh, no. Yannetti was aware that Kearney was going to start doing things that could result in criminal charges. Oh, no. Oh, no. They really want to get David Yannetti. This isn't just a bombshell. This is like the initial chain and a fission reaction, perceptible to the only like a microscopically discerning eye. This is a precursor of an absolute fucking hellstorm. I've said it before. Karen's fate. It's not just Karen's fate here. This whole project, quote unquote, the PR defense project for the Reed team is collapsing. Isn't it weird that LTL Media or Maz Media, Mazaz Media or whatever, deleted his whole YouTube channel? Then Mark Betterow puts out this weird statement overnight saying that he's going to stop doing appearances where people like charge super chats to hear his opinion. Something fucking weird's going on. And then also consider that Betterow was high school classmates with Jen Altman, and Jen Altman was the woman who initially encouraged Karen's friend Natalie, a PR person, who then got burned by Karen and her team. Jen Altman encouraged Natalie to link Karen Reed and her team up with TurtleBoy in May of 2023. And you got to remember, Betterow and Altman were not just classmates, they were classmates with John O'Keefe's deceased brother-in-law, Steve. And Jen Altman and Steve really did not like each other. So they're like, Betterow may have his own situation going on here. Those 4 attorneys that we're going to find out, wait till we get to the end of this paragraph. Those 4 attorneys, I think people were paid potentially, or at least there was some deals going on in the background to go out there and pump a defense narrative from the very beginning. This is really scary. Oh, I just got a donation, and I want to say thank you. Oh, you're so kind. Someone sent $5 and said, get yourself a coffee. You do great work in the morning. Oh, you're so kind. I will do, actually, now that I say that, I'll do my moment of levity. If you're enjoying this and you want to see me keep doing this, you can help me offset streaming expenses, and it's the end of the month, and you can help me not run out of food. I definitely haven't eaten today, but I did get a coffee. And that donation information's in the YouTube description as well. But let's continue here, because as I was mentioning, when we're seeing this content here with Yannetti saying to Kearney, oh yes, that's great that you're bringing all these people to the courthouse and a mic and a megaphone. That was when Kearney then started tormenting witnesses in the case, and it shows Yannetti having a knowledge that was going to happen and endorsing it. On 8/18/23, another typo, in response for Kearney's request for names of criminal defense attorneys who might want to appear on a YouTube discussion panel with him, Yannetti forwarded the names of 4 lawyers and their cell numbers and suggested how to approach them. All right, let's guess. Anybody have any guesses? Who are the 4 lawyers? Hold on, I'm going to read some comments. Oh, thank you. Someone said I have brilliant insights. Kelly Patine said, we reap what we sow, karma, no matter what you want to call it. It is starting to happen. Thank you, Jesus. I agree. Thank you, Jesus. Kelly Patine says, oh my God, this is awesome. I'm trying not to gloat, but it's so hard. Wow, they are going down. Oh, yep. And then Christina says, oh shit, justice baby, precursor. Yep. Marianne says, this explains why her mom and dad were not at the trial hearing. They knew what was coming. Yeah, I could see that. Mr. Burns, we were all wondering, where's mom and dad? What you do in the dark comes to light. Finally, justice for John is coming. The truth never moves. Someone says Betterow. Yeah, I think Betterow was one of the 4. Anyone else got some guess? Who are we think? Mark Elias is a guess. I'm thinking maybe Melanie Little. Let's see. Who's been around like since the very? I guess Melanie didn't pop up right away. But who's been around since the very beginning? Which defense like lawyer puppets or commentators since the very beginning. Nurse Kim, interesting. We could take a look at that one. Yeah, I think someone said the Madas. These are all lawyer, these are all very good suggestions. It's obviously a list of 4 names, so it's going to eventually come out. And those, I'm sure that text, clearly there's a text with those 4 names that's going to go into the evidentiary record. So if we see 4 attorneys just like stop talking about the case, I think that will give us a little bit of a hint as to what's going on. Someone suggests Emily D. Baker. That was from Barb 417. I think that's another good potential. What we really want to look at is, did Kearney have a panel discussion in August of 2023? Let's do it now, actually. I don't know if anyone, I'll research it right now. We can inductively reconstruct who these people were by seeing if Kearney had a Karen Reed panel in August of 2023 and who the lawyers were. Let's do it. I'm going to, Andrea Burkhart, or the Burkhart was a suggestion, all of the above. I'm going to do it right now. With you all. I'm going to, Vinnie Politan. Is he a lawyer? Is Vinnie Politan a lawyer? This is going to be so interesting. I'm going to go back. I'm going to actually do with you in real time. I'm not going to show you me scrolling, but I'm going to tell you what I find. I'm going to go. Right now, I'm in TurtleBoy's videos, his live shows, and we are going to go. We need to go back to August. What is the exact date? Sometime after August 18th of 2023. And we need to find out if there was a panel that TurtleBoy held with 4 lawyers, 3 to 4 lawyers. And I'm going to do that right now. So I'm back. I'm like 7 months back, so it's going to take me about, I'd say, 30 to 60 more seconds. So continue guessing while I continue scrolling. And we are going to put this together because this is not impossible to figure out. So it looks like it would be roughly, so it was 18 months ago, maybe 2023, the fall, yeah. So let's see, we're looking for August, roughly August 18th, somewhere or after August 18th of 2023. And don't worry, this is actually an incredibly valuable insight because we will eventually see this, but no one actually has the data yet. August 12th, 2023. All right, I'm basically here. All right, so we need to go from after, if you guys are wondering, it's from sometime after episode 604. Now, let's see. Do we get a panel at some point after 604? Anything? That's episode 607. My guess is that this is from right out. Maybe it took him like a month to set it up. What we really want to see is a panel. So what day was this from? We are, oh, that's right. I forgot to make a post on the, give me 1 second. I was going to make a post on the Facebook group, and I will do that right now. That reminded me, actually. But no, I think we're narrowing it in here. So what date was episode? That was August 22nd. So was there any panel on episode 607? Let's see. I'm going to screen this whole thing. When does he actually do a panel? Does he have one? Nope. No panel in episode 607. What about episode 608? What we're really looking for is any panel that occurred. Oh my God, I found one. The first one I can find is Bob Motta appearing on. So I think whoever guessed the Mottas, it seems like that's the first one I can find, September 19th. So 1 month after the message, I can find an interview with TurtleBoy and Bob Motta. It's not a panel. TurtleBoy brought Bob Motta onto his show, and it's episode 615 on September 19, 2023. And that, as far as I can tell, I'm screening the episode from, I think, late August. From August 26th. I'm going to screen one more to see if any defense attorneys pop up. Nope, no panel. So the first one I can find is Bob Motta in September of 2023. And then I'm going to take a look if there's another panel after that. So it looks like that was the first one. I don't think he actually did a 4-lawyer panel. It was just an interview with Bob Motta. And I'm sure there were more over time, but that was the first one. So interesting. All right. So one name has been found, I think, from the list. I think Bob Motta is going to have been one of those names. So congratulations to whoever figured that out. Let's see. I'm going to start someone said, oh, I see some more guesses here. Andrew M. Meyer is a guess. EDB was a co-worker of Jackson when he was a prosecutor. Steinbeck, he came later. Carl Steinbeck, or whatever his name is. Someone said they love Julie Grant. She is wonderful. Excellent commentator and very informed voice. I'm in Texas, so all I can think of is the YouTube lawyers, says Kelly. Lawyer, you know, Vinny, Emily Baker, Melanie Little. Let's see. Grant, let me be frank, says, this is why all those lawyers from Michigan cover this case because of that fool. Is he from Michigan? Christina says she found it. Yep. That's the Bob Motta episode, I imagine. What did I win? Linda Baden, Teresa's Caputo's wig. Brother counsel also from Michigan, Motta from Michigan. Oh, interesting. They got a little. Someone says Motta's from Illinois. That's close to Michigan. He has a ton of contacts in Michigan. All right. Okay, let's continue. So we just got to that 4-lawyer statement. Okay, that in and of itself is a big deal. But let's get back to reading more about the discussion. And that was footnote 5 we just read. So let's continue. Kearney reciprocated to Reed's team by passing along information he has come across, his own theories, and the names and contact information of certain potential witnesses. 6. On March... Oh, this is a big one. Just bombshell after bombshell after bombshell in this document. In March 27, 2024, Special ADA Ken Mello, on or about the final day of a grand jury sitting, asked the grand jurors present to return indictments against Aidan Kearney and Karen Reed for conspiracy to intimidate a witness. The requisite number of grand jurors did not vote to do so, and therefore the grand jury returned no bills. At the time of ADA Mello's presentation, he had not viewed any of the data from Kearney's phones. Remember, they don't get searched till November of 2024. Discussed Supra herein, and it was not presented to the grand jury. Oh no, they are going to be able to indict these fools. Oh no, they're screwed. The Commonwealth's investigation into these matters remains open. Aidan Kearney and Karen Reed are under active criminal investigation, and it knows of no bar against presenting them to another grand jury should it elect to do so. Oh, dear God. Boom. There you go. I don't know what more you want. It's hidden in there, but there it is, folks. There it is. That's as big as you can get. These two, Aidan Kearney and Karen Reed, are under active criminal investigation, open criminal investigation, and there's no bar that the Commonwealth knows of to prevent bringing the charge against in front of a grand jury again. And the March 2024 grand jury was not even presented the full weight of evidence because the materials kept coming in. And that's why grand juries can be represented evidence, because a case can grow. Just because you're a prosecutor and you think you've isolated a lot of the relevant material, that doesn't mean you have it all. My word. And there's obviously no double jeopardy or anything like that with a grand jury. You can be brought before a grand jury for the same thing with new evidence. Oh, my word. Oh, my word. Oh, my word. They're going to charge these two. Oh, no. I mean, oh, no for them. Listen, this is bad. This is apoplectically bad. This is as bad for Karen Reed and Aidan Kearney as possible. No wonder Aidan is so... the vibe is nervousness almost around him. And I think it's very possible. Oh, someone sent a donation. I just want to say God bless you for that. And thank you so much. I just saw it when I looked down. Just very touching. I got distracted. That's exactly why I shouldn't do it. But someone said, great to see you live. Definitely worth staying up for this live on the West Coast. Oh, you're still awake from the night before. It's late. It's 4 a.m. But God bless you and thank you. This is bad. This is as bad as humanly possible, though, for Karen Read and Aidan Kearney. Because if they both get indicted again, I mean, oh my God. And clearly there's new evidence now. And it's not just a matter of the concurrent indictments, which could come at any time. It's a matter of there's more than ample evidence here to prove a joint venture, a conspiracy, etc. More than enough. And they're under criminal investigation, and it's now public that that's the case, and it's still ongoing. Just bombshell after bombshell after bombshell. I can't even process what is going to happen next. It could get really explosive, folks. We could see anything from indictments to immunity deals to plea deals to jail for Karen Read, Aidan Kearney, or both. And even if Aidan Kearney is given a limited grant of immunity on just you don't get full immunity in Massachusetts. You don't get, there used to be a time where you could get a kind of immunity where you could go up on the stand and anything you said couldn't result in charges. But then some guy went up on the stand and confessed to a bunch of murders, and then the state changed it so that you can never get that type of blanket immunity again. You only get a very specific type of immunity. And just in the interest of helping to make sure everyone understands, it's transactional versus use immunity. And because I don't discuss this often because it's a very outdated concept, transactional immunity, I'm going to bring it up this way, sorry, one second. Transactional immunity grants a witness complete protection from prosecution for any crime related to their compelled testimony, while use immunity prevents the government from using the testimony or evidence derived from it against the witness, but allows prosecution based on independent evidence. So I think we're way more likely to see a limited grant of use immunity here for Kearney, if at all. But yeah, it has such big implications for Karen Read because it's a whole new charge, and there's a lot of evidence of it. It could result in her bail being revoked. It could result in trouble for her lawyers. It can result in all this evidence coming in. Kearney can be given immunity without his consent. He can be compelled by a forced grant of immunity to testify against her. And if that's going to happen, it really becomes like a fait accompli, because if Kearney's going to be forced to testify with no Fifth Amendment, why wouldn't he try to get a deal then? You're already going to be forced to testify. You're going to get some immunity on your charges. Why wouldn't you cooperate? That's what Brennan's doing to Kearney. Brennan's a monster. Just an absolute juridical monster. In a good way. And then you got Special Prosecutor Cosgrove, who has all this evidence, and it's just the worst possible situation for Karen Read and Aidan Kearney. You are just completely outmatched. The evidence is against you. The law is against you. The tactical posture is against you. The momentum of this all is against you. And you're both under active investigation. This is as bad as it gets. Both the Read team and Kearney took pains to conceal their actual relationship. For example, on May 3rd, 2023, Yannetti texted Kearney, "Dude, don't be offended if we don't shake your hand on the way into court. We want to maintain the separation and your independent investigation." And then he butt-slapped Kearney a year later. The butt slap. The Commonwealth wishes to delay the taint team procedures no more than absolutely necessary. This is for the other four phones now. The taint team procedure is necessarily a time-consuming one. Under the order, after examination and initial screening and determination of the potentially privileged material, that information is to be provided to defense counsel, who has 14 days thereafter to file objections with the court, which will rule on them. Only then, pursuant to the special master's designation, subject to modifications by the court, will the Commonwealth have the opportunity to examine the data on the 4 other devices. Consistent with this court's requirements, both the Honorable Joseph Macy and Stephen Veranu have filed their agreement to serve and be governed by this court's order. Since that time, 3 months have passed, and another month will pass before the scheduled April 30th oral arguments on the present issue, and then whatever the time this court requires to issue a decision. The Commonwealth suggests that this court could fruitfully forego oral arguments and decide this matter on the papers, which the court probably will, and I think Cosgrove's going to win. Alternatively, if the court believes oral argument to be necessary or helpful to its decision, the Commonwealth suggests that this court direct the clerk to immediately forward all submitted items to Mr. Varanu and communicate with him those terms not at all in question, and identify terms that may be substantially struck after the court hears oral arguments and rules. It's basically saying we need to get this process started. As undersigned counsel understands, the forensic examiner will need to do a separate search for each term, but each search is not particularly time intensive. Thus, the fruits of any particular term search may simply be removed from the potentially privileged category if this court rules a term invalid. In the meantime, the forensic examiner can progress in his work. So they really want to get this going. Really, really, really want to get this going. But folks, I'm telling you, that is explosive. That's absolutely explosive. Karen Read, Aidan Kearney under active criminal investigation. Karen Read, Aidan Kearney, blatant evidence on Aidan's phones in the possession of Hank Brennan and Robert Cosgrove showing communication. This is only a reflection of a small portion of one of the phones. There's another phone that is also already searched, doesn't have to go through the taint team procedure. That is already subject to a status report and has been turned over to Brennan as well. This motion was written on March 20th. The status report was March 25th. We're going to get something, folks. It's all crescendoing. It's leading up. It's coming. It's about to happen. That's what's going on. I knew it was big. I really wanted to do an in-depth reading on this stream to make sure we could look into it. But yes, it's big. It's important. It's happening probably today. If today is just a pro forma ruling where the judge says what Mr. Brennan has is in line with the order, that has big implications, but the hearing itself won't be bombshell. But if they actually argue it and Cosgrove or Brennan gets up there and says, look, even what we already have all fits within the parameters of the court order. Here's example 1, 2, 3, 4, 5. Oh my word, that hearing could be one of the most explosive hearings I've ever heard of in my entire life. So it could go either way, folks. I'm sure there will be either a stream or I bet Court TV or someone will pick it up because it's cross-docketed on the Kearney and Reed docket, this today's hearing. But it's not so much about this taint team review of phones in the future. It's about the material turned over to Brennan on Wednesday night, because when the judge got that status report and the material, the judge immediately provisionally impounded it and then ordered a hearing, which is what we're doing today. Now, with that said, I want to switch gears a little bit because I finally got this 20-pager opinion from the First Circuit Court of Appeals. And for at least the next 30 or 45 minutes, I want to go through not the factual background. We don't need to do that again. But I want to go through the motion on the decision, the actual decision on Karen Reed's weak arguments in the context of her federal appeal, and trace out why the inviolability of jury deliberations from Lawrence v. Stearns in Massachusetts in 1831 through to Tanner v. U.S. in 85 and Bluford v. Arkansas in 2011 and Pena Rodriguez v. Colorado in 2017 all made clear what most informed and prescient towels and other lay legal commentators knew from the beginning, which was there was very firm precedent preventing Karen Reed from re-examining the jury deliberations related to her first retrial, whether it be related to the 9-3 guilty vote on count 2 or otherwise. So we are going to take a second to read that, but before we do, I'm going to take some comments and questions about the last thing we were watching, because if we were reading. If you're just tuning in, the DVR should be on. You can go back and watch it. We were previously reviewing the bombshell motion confirming that Aidan Kearney and Karen Reed are under active criminal investigation for witness intimidation due to developing evidence that occurred after the two were no true billed on a conspiracy charge under 274-7 and 268-13B on March 27th of 2024. And not only are both of these two under active criminal investigation, but there is now confirmed to be evidence just from a part of one of Aidan Kearney's searched phones, of which there were two in November of 2024, that directly implicate and confirmed communications between Karen Reed and Aidan Kearney and between Reed through her lawyers as intermediaries with Kearney. And none of that is protected or privileged, and Kearney and everyone involved is screwed. That's my reading of this. It's over. It's bombshell time. The Berlin has fallen. The Russians are encircling. The Reichenplatz is cratered. The artillery fire is moving up, and it is within the Chancery Gardens. there is no option left in the bunker but for the secretaries and the support staff to start drinking and having uncontrollable parties with the family and the close relatives of the futile, fragile figure at the center of our chaos, Miss Reed, due mostly to the albatross that now hangs around her neck in the form of Aidan TurtleBoy Kearney, who has transmutated from his original shelled form into not really a golden-winged albatross, but I'd call it more of like sort of a defeated albatross, just sort of drooping with the reflection of its own self-enforced errors. And that albatross will be pilloried and otherwise displayed by Mr. Hank Brennan during Karen Reed's retrial as a consciousness of guilt that Reed will bear around her neck forevermore, and will not only tank her with the jury in her retrial, but will also display to the world the true extent of Karen's real character, which is cunning, manipulative, ruthless, egomaniacal, fame-driven, and vengeful. And then the real ramifications of Karen's bad choices will come to bear in the form of a corrupted soul laid bare before the world, deprived of support, stripped of her false facade of innocence, fraud, and fame, and forced to confront a moral reckoning defined by catharsis and atonement and hopefully contrition and apology, lest Karen be instead swallowed whole by fate's inevitable penalty without repentance that will be imposed if she ends up not being able to embrace that contrition and atonement and apologies. It's a fait accompli. It's a very bad situation for all parties involved. There's no way out of it. There's no last moves. There's no play. There's no desperate last salvo that will salvage this situation. It is simply a fait accompli with the crushing weight of Hank Brennan's tactical genius and Aidan Kearney's indiscretions and the procedural posture of this case, all crescendoing such as to form a boulder that will roll down and not just crush Karen Reed's hopes, but place her back down at the bottom of the hill of atonement, and hopefully this time, instead of trying to fight against truth and push that boulder up the hill over and over and over again, Karen will realize that atonement, although it requires a very difficult process of tunneling through the hill, is what will actually get her to move forward in life rather than be stuck tormented in this Joycean cycle of Hegelian proportions, as if rendered a main character in a historic novel that showcases the rise and fall of human moral virtue. What do you think? I thought that was pretty well said. Someone said epic. Someone said if this is Alessi arguing, he would take all day. No, I think it's going to be Kearney's attorney because it's a collateral action in the Reed case. But you said Bradel could talk, Alessi could talk all day. Imagine me up there. I'd be like, Your Honor, see, Hegel's conceptualization of the development of modern Western thought really undergirds the legacy of, or the precedential weight of these decisions. And, Marty Weinberg talks about the Stuart Kings, but I think we really got to look back to the kingdoms of Bohemia if we want to understand the origins of this doctrine. And then Grant, Attorney Ellis, what the... Stop. Yes. Okay. Someone said this is genius. I'm here for it. I don't know what that means. I mean, I don't understand what it's like to consume and say words at the same time. So if what I was just saying, the historical framing of Karen Reed's Sisyphean, Hegelian, Joycean torment is an actually accessible and cogent socio-political, moral, historical synthesis in a way that you can understand, that kind of blows my mind. I mean, I'm glad in some ways because that's how I just think about it, but actually transliterating it into words is quite difficult. But also, this is what you get when I stream in the morning. What you're seeing at night is just me at like 40% capacity. This is probably closer to 80 or 90. But yes, I do need to take some time while we're reading this to kind of read your comments, reflect a little bit, just kind of do some dramatic readings of my thoughts, because just reading court motions over and over and over again and explicating them does get tiring. All right, there's a lot of good conversations going on in the comments about Bob Alessi. You guys can continue to discuss that. And now we're going to read, if you're just tuning in, we were reviewing previously a major motion that in the Aidan Kearney case, where if you want to, it's on my Twitter feed, but if you want to see specifically the bombshell, go to page 7, last paragraph, nope, sorry, page 8. Paragraph 2, 3, page 9, paragraph 1, 2, footnote 5, 6. Read that. Read everything on page 8, starting at the top of page 7 if you really want to get the context, but start middle page 8. Read everything on page 9 of this decision. It's incredibly fucking important. And we'll hear more about this, I'm sure, over the coming days. But there you go, folks. Nestled in the motion like a beaming, glittering kernel of truth that sheds the garlands of flowers from our chains of polemical liberation and brings about cogent rhetorical discussion of matters that have been so long suppressed within the public sphere. It is a wonderful moment for me, a wonderful moment of vicarious catharsis. The moment Miss Havisham was forever denied because her motives were insidious, afforded only to those who seek benevolent catharsis by way of history's truth unfolding before all of the world to see in front of the national news and in a way that reflects the deferred dreams of a pursuit of justice that so many of us thought would never come but instead dry up like a raisin in the hot desert sun. Okay, now let's go ahead and take a read of this federal appeal. Now, what we're not going to do is we are not going to read the full factual background. We will read the first paragraph, then we're going to skip the factual background, and then we're going to go to the analysis, okay? Because I don't want to do 20 pages right now. On April 16th, this was Karen Reed losing. I forgot I have to do the procedural posture. Okay, so what happened was Karen Reed, during her first trial, there was a mistrial. After the mistrial, Karen Reed filed a motion to dismiss based on all sorts of ridiculous claims about what the jury had said during deliberations, etc. Her motion to dismiss was denied. Karen filed a 211-3 emergency interlocutory appeal to a single justice of the Massachusetts SJC. That single justice referred the matter to a full panel of the SJC who, in a unanimous opinion, I think sometime in the fall of 2024, rejected outright Reed's arguments, affirmed Judge Cannoni's motion to dismiss due to a lack of substantive argument for Reed from Reed as to the manifest necessity issue for the retrial, which of course Judge Cannoni was correct to grant after 3 notes from the jury saying they were irretrievably deadlocked, coupled with Reed's weak arguments about trying to pierce the veil of jury deliberations, and then Reed's ridiculous request to ask for a post-panel voir dire or inquiry into the jurors' deliberations. Then what happened was, after Reed lost that SJC appeal, she appealed the loss of the SJC loss up to the federal district court in Boston on a collateral writ of habeas. So she used USC 2241, which is like a writ of habeas when you're in pretrial custody due to a state-level criminal proceeding. She used a writ of habeas under 2241 in order to make a collateral double jeopardy claim and attack the SJC's ruling because you have to raise a federal question on appeal. So she used the hook there under the habeas petition with a double jeopardy Sixth Amendment sort of umbrella to get into federal court. Now, in a 28-page opinion that I would call a historical treatise, Judge Dennis Saylor IV of the Boston Federal District Court just dismissed Reed's arguments on every prong and obliterated her under the precedent, citing a lot of the cases that are very near and dear to my heart. I'm pretty sure he did. I don't know if he cited Lawrence v. Stearns, but he definitely cited the fact that the common law precedent goes back hundreds of years related to the inviolability of jury deliberations and the fact that agreements among jurors are not verdicts. And then, of course, the judge also cited Tanner v. U.S., Bluford, Pena Rodriguez. Reed then, after losing, filed a motion to stay her state court proceedings while she appealed Judge Saylor's decision up to the First Circuit Federal Court of Appeals. That motion for stay in front of Judge Saylor was denied. So then Reed goes up to the First Circuit Federal Appeals. The brief goes in. The reply brief from the state comes in from Caleb Schillinger, 50 pages. We read it on this stream. It was excellent. Then Reed submits a reply, and then the reply from Reed only came in 2 days ago. And then Reed also submitted another motion to stay her state court criminal proceedings with the First Circuit Court of Appeals. So we're all waiting for a ruling on the stay and etc. Instead, last night at 4:35 and 4:36 p.m. respectively, the First Circuit Court of Appeals dismisses completely Reed's appeal, completely denies it, affirms Judge Saylor's opinion, and then denies the stay in one fell swoop, allowing Reed's April 1st, 2025 retrial to move forward. That's the procedural posture of how we got to the First Circuit. This is basically the last court in the hierarchy where you have an automatic right of appeal. Now Reed's only option is to do what's called a petition for a writ of certiorari to the Supreme Court of the United States, which is not an automatic appeal. You're petitioning for the right to have your case reviewed. In order to have your case reviewed, you have to pass the Rule of 4, which is an informal conference among the Supreme Court justices. You have to get 4 votes to get the case heard. Of 8,000 petitions filed yearly, maybe between 80 and 100 are actually heard by SCOTUS. There's absolutely no chance Reed's case gets heard, and here's the reason. This is a very political issue, and the Bluford decision was written by Chief Justice Roberts. The dissent in Bluford, which is really the argument Reed tried to make here through Marty Weinberg in federal court, the dissent in Bluford only has liberal support, and you only have 3 liberals right now: Justice Ketanji Brown Jackson, Justice Kagan, Justice Sotomayor. Now, in order to get the case heard by SCOTUS on a petition for writ of certiorari, you would need that 4th vote on the court. And there's no way, because Chief Justice Roberts himself, the only person who kind of sways between the Republican and the Democratic bloc on the court, there's a caveat to that, because Kavanaugh and Coney Barrett are sometimes wild cards. But Chief Justice Roberts wrote the Bluford majority. So you're never going to peel him off if you're Reed to get the 4th vote for review on a petition for a writ of certiorari to SCOTUS on this. You're not going to peel off Justice Coney Barrett if you can't peel off the Chief Justice. You're not going to peel off Justice Kavanaugh if you can't peel off Coney Barrett or the Chief Justice. And you're not going to peel off Justice Gorsuch. And there's no chance you're getting Alito or Clarence Thomas. So there's just no way Reed has a 4th vote here to get her petition for certiorari granted. It's just not happening. It's political, and there's no way Sotomayor, in her extraordinary dissent from Bluford, has the necessary support to overturn that kind of precedent yet. Maybe Marty Weinberg is 20, 30 years ahead of his time, and there will be a time when there's a liberal majority on the court where not only he could have got the 4th vote for the review of the petition for the writ of certiorari, but also a win on changing the scope of Bluford beyond just the parameters in Pena Rodriguez v. Colorado from 2017. But we're not there yet. We are just 100% not there yet. And Marty Weinberg is 30 years ahead of his time, and he was never going to be able to whip this. And he could lobby the Supreme Court himself, and he's still not going to be able to win this, because Chief Justice Roberts' opinion in Bluford is a very firm pillar for the court's Republican majority. And even the moderates. So just not happening. I hope that all made sense, too, the procedural posture of how we got here and why Karen's federal appeal is completely ill-fated. But yes, I hope that made sense. Thanks, everyone, for tuning in, by the way. It's about 7:30 in the morning on this Friday, March 28th. There's a 10 a.m. hearing in the Karen Reed and Aidan TurtleBoy Kearney cases, which, if you missed the earlier part of the stream, I think will be mostly pro forma, which is to say it's mostly Kearney trying to say that material from his phones, which are explosive, and we already now know, confirmed direct contact between Kearney and Karen Reed, and Kearney and Reed's lawyers, and Kearney and Reed with Reed's lawyers as his intermediary, and Kearney and Reed's family with the lawyers as an intermediary. It's just going to be about whether the material already turned over by the special prosecutor in Kearney's open felony criminal cases for witness intimidation of Reed trial witnesses, and Lindsay Catani as well, and wiretapping, whether those 2 phones and a status report related to their contents and a USB drive are in line with the existing court order under Lampron and Rule 17 related to their production and the scope thereof. Once that's confirmed, that's it. There isn't really a debate. Once the judge says there's a provisional impoundment order on the material, but once the judge says this is in line with my order, it's discoverable, it's pursuant to what was supposed to be turned over to Mr. Brennan, That's it. That's today's whole argument. Maybe there's some other stuff they'll deal with about going forward, Kearney's taint team motion and stuff like that related to his other 4 phones. But no, folks, that part is done and dusted. There's no argument from Kearney. That's probably why he's going on Zoom. It's going to be a horrifying day in court for him. We may even get read some contents of those text messages if Kearney's lawyer doth protest too much. I could see the state standing up there and being like, Your Honor, Tim Bradle's arguing that there's no these materials are not pursuant to the order, but here's 20 text messages, here's 40 text messages, and here's why each one aligns with the subsection of this court's order. That's what I would do. I'm not a lawyer, though. I'm a towel. Nothing on this stream is legal advice. If you have questions about the law, you should get a lawyer. If you have questions about how to find unconditional love and provide hope in the others for the same in a world that is very hostile to that concept, then you should get a towel. Towels are very good at that. Towels don't give up. Towels are adorable, endearing, and lovable. Also, as I mentioned, my name is GrantSmithEllis. Thanks very much for being with me. And I got another $5 donation as we were reading through or getting ready to read through this federal appeal, and I was explaining the federal posture, and the person said, Grant, you explained the case very well. And I want to say thank you. I do my best. And by the way, you don't have to send donations. I just want to keep reiterating this because this issue keeps coming up, and I don't like how other people do their streams in this way. You have a comment, you have a question, and I think it's merit-based and not derogatory or discriminatory. I will answer your question. I will read your comment. I don't like this idea that people who can send donations or whatever should have more of a say. Your opinion is judged on its merit here, and it always will be. And if you send donations, it's more to just keep me alive and keep my brain fed to the point where its caloric intake sustains the repetition of this information from memory and verbatim as I'm somehow able to do. And sometimes I think I close my eyes just to show you all that there's nothing to read. Even if there were things around me, there's nothing that I'm reading. I'm literally just looking in my head, and I can kind of see all this material. Just everything that I'm bringing up, I can just kind of bring up not just an image of it, but the whole document. And then I can be like, oh, I want to go to page like 29, and I just like flip through it. But as I'm speaking sentences and going from document to document to document, I'm just kind of like ahead of myself, and I'm already like, oh yes, I'm going to reference that, and I'm going to reference that, and I know what page that is on. It's a very interesting way to think, but I think it does require caloric intake to sustain along with coffee. So your support does not go unnoticed, and your willingness to help support this public information service will always be appreciated. All right, so let's read the factual background. We know the procedural posture that got us here, and then let's go into the analysis, and then we are waiting for the 10 a.m. hearing, which Aidan Kearney isn't even going to, although I think all the 10 a.m. hearing, as I said, is really going to confirm is the predictions or the foreshadowing in that explosive motion that we were just reading related to the direct communications between Kearney, Karen Reed, and Karen Reed's lawyers, and the fact that they're both under criminal investigation. On April 16, 2024, Karen Reed's trial began in Norfolk County Superior Court in Massachusetts on charges of murder in the second degree, Mass General Laws 265.1, manslaughter while operating under the influence of alcohol, Mass General Laws 265.13.5, and leaving the scene, personal injury resulting in death. After 37 days of trial, the charges were submitted to the jury for deliberation. During approximately 28 hours of deliberation, the jury sent 3 notes to the trial judge informing the court that the jury was increasingly deadlocked. On July 1st, 2024, after receiving the 3rd note, the trial judge declared a mistrial. A retrial is scheduled to start on April 1st, 2025. After the mistrial, Reed moved to dismiss counts 1 and 3 on the basis that the double jeopardy clause barred retrial. The trial judge denied the motion, and the Massachusetts Supreme Judicial Court affirmed. And then, as I explained the procedural process earlier with 211.3, Reed then, that's the footnote 1. Reed then filed a habeas petition in federal court under 28 U.S.C. 2241. As I also said, the writ of habeas for a pretrial custody proceeding in a state court that's being challenged in federal court under a constitutional question to prevent the state court from retrying her on those counts, arguing that a retrial would violate her constitutional double jeopardy rights. The United States District Court for the District of Massachusetts denied her habeas petition, and Reed now appeals that decision. For the reasons that follow, we affirm Judge Saylor's denial of Reed's motion. So, we're not doing the background of all the facts, because that is exactly what they just laid out. the court laid out, that is exactly what we've talked about, the procedural background, the Reed's mistrial, the 9-3 guilty vote on count 2, the jurors coming forward after the trial. Now, firstly, the court reviews whether it has jurisdiction to see and what's the standard of review here. And Reed is properly before the court under 2241, obviously. I'm just summarizing what's on your screen. And then Reed also raises Sixth Amendment issues, so that means she's also in federal court. So the question here is whether the juror court terminated jeopardy, whether the trial ended in a way that prevents a second trial. Reed offers 2 alternative arguments. Both are going to get turned down. First, that the court erred because there was no manifest necessity to declare a mistrial on 2 counts. And second, that the jury effectively acquitted her on these 2 counts. We're going to find out neither of those fly. Discussion, manifest necessity. We begin by summarizing the legal principles relevant to Reed's manifest necessity claim. Under our constitutional framework, a defendant generally may not be retried for a charge if, after trial begins, the court discharges the jury without the defendant's consent. This stems from a defendant's valued right to have her trial completed by a particular tribunal. But this right is not absolute. It is subject to the rules of manifest necessity, quoting U.S. v. Perez. Under the doctrine, that's from like 1824, yeah. Under the doctrine of manifest necessity, trial judges may not foreclose the defendant's right to have the particular jury reach a verdict until a scrupulous exercise of judicial discretion leads to the conclusion that the ends of public justice would not be served by a continuation of the proceeding. So that's the standard for meeting manifest necessity. And we are going to see very quickly why Judge Kearney easily established that standard. And the federal court does not buy in any way whatsoever to Reed's, what I would argue, very weak arguments for why 3 notes from jurors saying they were increasingly deadlocked and Reed's failure to object to the mistrial were anything but confirmation that manifest necessity had been established. That's basically the conclusion we're going to get to, but federal judges say things in very eloquent ways, especially when they're on the First Circuit Court of Appeals, and so we're going to take our time to read this just so we can become more erudite and eloquent rhetoricians and legal writers. Although, as mentioned, I'm a lay towel, and nothing in this stream is legal advice because I'm not a lawyer. And you should get a lawyer if you have questions about the law, and you really should only get towels if you are trying to show the world that unconditional love is possible despite the seeming hostility at every turn towards that very beautiful and sublime concept. For really, what is the purpose of being alive if not to express one's love, either for one's community, for the public at large, for one's form of government, for the country in which one lives, for other people, for one's family, or otherwise? In the absence of such love, human existence becomes nothing more than a passive footnote within history's otherwise fickle pages. It's love that makes human cognition so special and brings about the best of our shared living arrangements on this God-forsaken planet. And in some ways, that's what gives me so much hope. No matter what happens, I always believe that there is this undercurrent of underappreciated, ever-suppressed love that runs throughout most human beings and runs throughout most societal interactions, but then just gets suppressed by people who realize that that kind of interaction doesn't sell papers, doesn't drive views, doesn't bring in money. It just makes people happy and content. And I don't know, on the whole, if the powers that be and all these nefarious forces involved in these cases actually want people to be happy. I think it's way more for them about taking out the torment from their own lives on others than actually seeing people be happy. And that worries me because it makes me feel like it's a self-perpetuating cycle. Someone powerful becomes unhappy, so they want the whole world to be unhappy. And that, folks, is the curse of our society. How did I go from manifest necessity to human happiness? All right, so let's see. Under the doctrine of manifest necessity, trial judges may not foreclose the defendant's rights to have that particular jury reach a verdict until a scrupulous exercise of judicial discretion leads to the conclusion that the ends of public justice would not be served by a continuation of the proceedings. The Supreme Court has defined manifest necessity as meaning a high degree of necessity. Renico. Good case. I think Trevor McIntyre really likes the Renico case. That's going to be your fate, Trevor McIntyre, forever associated with the Renico case. A deadlocked jury is the classic example of a situation where declaring a mistrial is manifest necessity. I would say so. The government may then retry the defendant for the charge or charges on which the jury deadlocked. Relatedly, while a trial court's decision to declare a mistrial based on manifest necessity is accorded great deference, that deference does not end the inquiry and can be overcome. That was Arizona v. Washington that Marty Weinberg cited before he went on his eloquent soliloquy about the Stuart Kings, because he must have known that Judge Saylor really likes history references. Because the decision affects a defendant's constitutionally protected interest to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her, courts have an obligation to satisfy themselves that the trial judge exercised sound discretion in declaring a mistrial. For example, a trial court does not exercise sound discretion if it acts irrationally or irresponsibly or for reasons completely unrelated to the trial problem which purports to be the basis for the mistrial ruling. So the court's basically setting up to say Judge Kearney was correct to declare a mistrial because neither of those things happened. Reed argues that the trial judge made a precipitous decision in declaring a mistrial, emphasizing only 2 minutes passed between the trial court announcing that it had received a third jury note by stating the jury is at an impasse and discharging the jury. Reed also argues that the record suggests that the court did not consider alternatives to declaring a mistrial or even discuss the possibility of a mistrial with the parties. You're ridiculous, Karen. In response, the Tui Rodriguez charge is the alternative. In response, the Commonwealth, that was through Caleb Schillinger, who wrote an excellent brief, multiple excellent appellate briefs in this case. The Commonwealth counsels that we take a broader view of the relevant timeline. I have a feeling the court's going to agree with the Commonwealth. It argues that the trial court took careful steps throughout deliberations in responding to the jury's notes. Oh, there must be actual pollen in the air. Sorry about that. Allergies kicking up as we get closer to the start of spring here. It argues that the trial court took careful steps throughout deliberations in responding to the jury's notes and only declared a mistrial when it was clear after the third such note that the jury was truly deadlocked. The Commonwealth further argues that federal courts have never required a trial court to take any particular steps when confronted with a deadlocked jury, and that the judge exercised sound discretion under these circumstances. In addition, the Commonwealth argues that, contrary to Reed's suggestion, the trial judge was not required to ask the jury about a partial verdict or poll individual jurors, as doing so may have improperly risked coercing a verdict. Exactly right all around. In determining whether the declaration of a mistrial reflected a trial judge's sound discretion and was reasonably necessary under all the circumstances, we consider whether the district court explored other options, gave counsel the opportunity to object, and acted after sufficient reflection. United States v. Conderlio Sartana, United States v. Torbio Lugo, I saw that one before, and Brady v. Samaha. Stating that whether the record indicates the judge has considered alternatives to a mistrial is significant and is affording counsel an opportunity to be heard on the subject. That's why Kearney pointed out the defense counsel was no shrieking violence. They didn't need shrinking violets. They didn't need an opportunity to be invited to object to the mistrial. They could have if they wanted to. They didn't. Among other factors, the amount of time that the judge takes with the mistrial decision is relevant. A precipitate decision reflected by a rapid sequence of events culminating in a declaration of a mistrial would tend to indicate insufficient concern for the defendant's constitutional protection. Brady. But there is no mechanical rule or set of specific steps that a trial court must follow before declaring a mistrial due to deadlock. Rather, the court must only take some step to ensure the jury is actually deadlocked. That's exactly what Schillinger argued. We agree with the Commonwealth and the district court that we must consider the trial court's actions throughout the jury deliberations and not limit our review solely to the court's response to the third jury note. Thus, we return to the judge's actions during that period. Recall that the trial judge received the first jury note about its difficulty in reaching a unanimous verdict after the jury had been deliberating for around 19 hours. Upon receiving the note, the trial judge shared it. Oh, goodness, drop my water bottle again. Upon receiving the note, the trial judge shared it with counsel and heard their arguments on how to respond. As discussed, Reed's counsel urged the judge to give a Tui Rodriguez instruction, arguing that the jurors had exhausted all manner of compromise and were at an impasse, using Reed's lawyer's words against her. In other words, Reed's counsel encouraged the court to find that the jury had failed to reach a unanimous verdict following due and thorough deliberations. See Commonwealth v. Jenkins, noting that the giving of a Tui Rodriguez charge generally reflects a conclusion by the court that the jury's deliberations were due and thorough within the meaning of the then applicable Mass General Laws 234-34. This is particularly relevant because under Mass law, once a jury, after due and thorough deliberations, returned to court without having agreed on a verdict and is sent back out for further deliberation, but then returns once again to, I found an error in a federal court decision, but then returns once again to report a deadlock. Victory for Towel. I found an error in a First Circuit Court opinion. Bottom of page 13, top of page 14. Gold star for Towel. But then returns once again to report a deadlock. The court cannot require them. I think only very few people actually get excited when they can find typos in court opinions. We're finding one in a federal First Circuit opinion. That's impressive. That means everybody who read this missed that, except for Towel. Wait, maybe I didn't. Maybe I missed the two. But then again, returns to once again. Oh, it was hiding before. I thought it said, but then returns once again, report a deadlock, but it actually says, but then returns to once again report a deadlock. See what I mean? I got ahead of myself. There is no way a federal court would ever have made that kind of error. I was like, no way. It's just the word order was confused. But to my credit, I was looking very discerningly. The court cannot require them to continue deliberating unless the jury consents. MGL 234A 68C. However, after the first note, the court declined to give the instruction and sent the jury back to keep deliberating because it concluded that there had not yet been sufficient time for the jury to have engaged in due and thorough deliberations. After the second jury note, Reed's counsel pressed a second time for the Tui Rodriguez instruction, arguing that the jury was hopelessly deadlocked. The Commonwealth again argued it was premature, but the judge found that enough time had elapsed to conclude that the jury's deliberations were due and thorough, and thus proceeded to give the instruction. It was only after the jury's third report of deadlock, when the court was statutorily precluded from ordering the jury to continue deliberations without their consent, that the trial court declared a mistrial. Considering the court's actions throughout jury deliberations, we find that the record, read as a whole, reflects only that the court acted diligently to avoid a mistrial. After the first note, and after consulting with the parties, the court declined to give the Tui Rodriguez instruction and sent the jury back to deliberate. After the second note, the judge again consulted with counsel before concluding that the jury had engaged in due and thorough deliberations such that it was appropriate to give the instruction. The court then received a note in which the jury made clear not only that unanimity remained unobtainable, but also implied that the jury would not consent to further deliberations because such deliberations would be futile and only serve to force the jurors to compromise their deeply held beliefs. Without that consent, the court could not have been bound by statute. Without that consent, the court would have been bound by statute, the constitutionality of which Reed does not challenge, from compelling the jury to continue deliberating. Statute made Judge Kearney do it. It was manifest necessity. MGL 234A 68C. While we agree there is force to the SJC's view that the more prudent course may have been to read the third note to counsel and allow them to weigh in, as the judge had done upon receiving the prior two notes, the court's decision not to do so with the third note was within its discretion, particularly when faced with the circumstances above. Reed further, so the new precedent there, judge doesn't have to read the third note. Reed further argues, with the benefit of hindsight and the post-trial statements from some jurors, that the trial court should have considered, as an alternative to declaring a mistrial, asking the jury to specify on which charges it faced deadlock, or if its final note related to some or all of the charges. But our point of reference is the court's knowledge at the time it declared the mistrial. See Washington. A reviewing court must consider the particular problem confronting the trial judge. And then also U.S. v. Elliott. A reviewing court must determine whether such a manifest necessity existed at the time a mistrial was declared by the district court. And U.S. v. Cameron. same. We cannot say that a clear alternative under Torbio Lugo was available to the court at the time of its decision for the following reasons. At that time, the only juror statements that the court had were the jury notes in front of it. The notes stated that the jury was unable to reach a unanimous verdict. First note, that the jury was deeply divided by fundamental differences in their opinions and state of mind, and that consensus was unattainable. Second note, and that the jurors' perspectives were starkly divided, with some believing the evidence established the elements of the charges, underlined, I emphasized that in my prior analysis, beyond a reasonable doubt, and others finding the evidence did not sufficiently establish the necessary elements of the charges. Third note, emphasis added. The emphasized portions were the only time that the charges were mentioned, and the jury notes contain no indication that the jury might have reached unanimous agreement on any individual count. Reed now argues that the court should have considered that charges might refer only to the lesser included offenses embedded within count 2, and accordingly the court should have inquired into the possibility of a partial verdict pursuant to MGL Mass Rules of Criminal Procedure 27B. That rule, providing that the court may first require the jury to return verdicts on charges upon which the jury can agree before declaring a mistrial as to any charges upon which the jury cannot agree. But the interpretation of the note that Reed now advances only seems plausible in light of the post-trial statements that did not exist and were therefore unavailable to the court when it had to make its decision. I agree. On their face, the notes appear to make a series of definitive assertions that the jury could not reach unanimous verdict. Thus, while it would have been within the court's discretion under the Rules of Criminal Procedure 27B to inquire into the existence of a partial verdict, there was no apparent need to do so here. Nor was this alternative proposed by Reed's counsel during the two opportunities counsel was given to consult with the court regarding the jury's reported deadlock or upon learning that the jury had returned to report an impasse for the third time. Footnote 6. We note that there is nothing in the third note that changes this calculus. Indeed, the third note, which says that the jury remained divided on the charges, is the note that is most facially inconsistent with the possibility of there being a partial verdict. Agree. Yeah, Reed got hammered here. It follows that at the time of the court's decision, considering the information the court had before it, there was no readily apparent alternative to declaring a mistrial. For those reasons, we are satisfied that the trial court exercised sound discretion in declaring a mistrial. Boom. B. Post-trial statements. Next, Reed argues that several jurors' post-trial statements established that the jury actually acquitted her on 2 counts, such that she not be re-prosecuted on those counts. As an alternative remedy, she requests a hearing as to the original jurors to ask the original jurors whether they acquitted her on counts 1 and 3. This section, Reed gets even more decimated, and it's short too, so they really didn't buy the argument. They didn't even bother to really entertain it. Actually, let me take some questions before we go on to whether an acquittal occurred. And spoiler alert, it did not. All right. Let's see. Oh, good morning, Murder by Maestro. Great to see you. Angela says she loves the towels giggle. I do giggle sometimes. Someone said that I'm brilliant. Oh, thank you, Drew Drops. That's very kind of you. Thank you so much for those of you who've been tuning in. My name is GrantSmithEllis. Kelly Patton said, I think we are all doing a happy dance right now. The happy dance is long overdue regarding that case. Yep. Soil Nina says, great analysis. Thank you. Job well done. Oh, thank you. Who thinks this is because of Brennan's determination, asked Rita. I think this is because of Hank Brennan's determination. Let's actually add a special towel poll. Hold on a second. I'm going to do a towel poll. Let's see how you all are feeling this morning. All right, start a poll. Are you celebrating this morning in light of evidence on TurtleBoy's phone of texts with Karen Reed? There you go. Special towel poll. Yes, no, add option, you're a towel. There you go. I ran a poll for you all. Let's see how we are all feeling. The results lean strongly in favor of yes, with some people saying that I'm a towel. I'm very pleased to be a towel. I do not do... You're a towel, Murdered by Maestro. I do not deny being a towel. There is no one who said no. It's either yes or you're a towel. I see towel, I click. Someone asked, does the Commonwealth have all 6 of TurtleBoy's phones? If not, what happens if TurtleBoy wipes or get rid of the phones? They have all 6. 2 have already been searched in November of 2024. That's where we got that material about what Kearney had been saying to Karen and Alan Jackson and David Yannetti. The other 4 are pending review by a taint team. Lucy in the Sky, great reference, by the way. I love the Beatles. New here morning. I don't understand the meaning of towel. Oh, well, the TurtleBoy fans mocked me at one point for being a towel. And they were like, oh, Grant's pronouns are towel. And I was like, well, I should just own this. So then I was like, I'm just going to become a towel. And the towel from South Park is a government-created robot towel. And it smokes a lot of weed and ends up in complex social situations that it solves in a naive, kind of endearing and lovable way. And so, yeah, I'm a towel. And I thought that was a very fitting metaphor for my existence, because towels are the fabric of the universe. Do the towel roll. Let's see. A lot of people laughing. I must have been something. Happy dance for towel, says Marianne. Let's see. Get your coffee because you will definitely need to be awake and have energy for the happy dance you're going to be doing. Murder by Maestro. That's true. I'm reading back through some of the... someone's saying, is this a new document? So, Murder by Maestro, we're reading through the federal court opinion, but this is the document you want to see. It's right up on my Twitter. Let me show you the initial page here. You want to find this document. It's the Commonwealth's opposition to defendants' proposal to compel screening of seized devices for reported privilege material. Now, the first 8 pages or 7 pages or so are very interesting, and you should read them if you're interested in the 4 phones from Kearney that have not yet been searched by the Commonwealth. But if you really wanted to see the bombshell, start about page 8, paragraph 2 in the middle there. And then you should definitely pay attention to the fact that there is just a cursory review, and this was on March 20th, although the document only came out overnight. Just a cursory review of a part of one device from Kearney brought forth evidence of direct communication between Karen Reed, Alan Jackson, David Yannetti, and TurtleBoy, and the 3 of them individually, and TurtleBoy. And the document also confirms, if you go down a little bit further, the nature of those contacts. So there are texts, according to this motion, from Reed directly to Aidan Kearney about information about the case. And there's even more evidence that most likely was filed on Wednesday night of this week by Special Prosecutor Cosgrove. Because remember, March 20th is this motion up on your screen. Then Cosgrove probably over the next 5 days went through the rest of the first phone and then the other second phone, which don't need to be reviewed by a taint team. They're already searched and in the possession of the Commonwealth in Kearney's criminal cases. So Cosgrove on the Wednesday night files a status report overviewing everything he found on both phones and submits a USB drive. That gets handed over to Brennan and Reed's defense and immediately subject to provisional impoundment. And at the same time, an order goes up in the docket for a hearing with the parties in front of the judge as soon as practicable. There will be a motion judge, probably not Judge Cannoni. So at 10 a.m. today, we're going to have a hearing which is specifically about whether the material handed over to Brennan by Cosgrove is in line with the prior court order under Rule 17 and Lampron for Cosgrove to turn over material you're literally looking at the screen at just part of it as to communications between Karen Reed and Kearney and her lawyers for the purposes of tormenting witnesses in Reed's criminal case, specifically between April 1st and October 5th of 2023. Now, there's another big explosive component here, because it's not just all these communications between Reed and Kearney and her lawyers. It's that if you go to the footnotes here, you will see that Yannetti was coordinating PR lawyers to go on streams with TurtleBoy, and we think we found one from right after this message was sent with a lawyer named Bob Mata, I think. So it's possible Mata is one of the 4 names and mentioned in footnote 5. And then you see, read footnote 6. What does it say at the bottom there? When the Commonwealth got a no true bill trying to indict Kearney and Reed, they didn't even have the benefit of reviewing Kearney's searched phones, because that didn't happen until November of 2024, and the no true bill was in March of 2024. And then it says at the bottom there, the Commonwealth's investigations into Reid and Kearney, it says these matters, remains open, and the Commonwealth knows of no bar to prevent them from returning to the grand jury should it elect to do so. That's fucking huge. Yes, Aidan was completely misleading the public. Just from a cursory search of a part of one of the devices, there was already material confirming direct communication between Kearney and Reid. It wasn't records of signal communications with blanked out content. It's the actual fucking content. I'm telling you, this is a very, very, very intense situation. Lucy in the Sky with Diamonds says, thanks, Grant, you fabric of the universe. I love it. Marianne Ninzo reminds us she is an honorary washcloth. That's true. TurtleBoy fans can't even hold a candle. Hit the like button, folks. It only takes a second. Hi, Carrie Gold. So nice to see you. Welcome. Yes, folks. So I'm trying quite hard to do more streams on YouTube, and it really helps, apparently, for the channel if you click the like button and click subscribe from within the video while we're watching. We don't know. No, you're a towel. We don't know exactly what's going on at today's hearing. It's going to be mostly perfunctory in the sense that I think it's going to be primarily about just confirming the material turned over to Brennan is in line with the order. But maybe we're going to get more material read out loud. That would be great, from the phones to prove that they're in line with the court order, and that could then be explosive. The footnotes are always great. Also, Murder by Maestro says, wait, but we know what Yanetti's sending that message means, but it's not Karen communicating with Aidan. Yeah, but what about this one, Mr. Murder by Maestro? Kearney's phones contains text messages not only between not only Kearney and Karen Reid, but Kearney and attorneys Yannetti and Jackson as well. The text exchanges also make clear that the Reid team was in telephonic and email communications with the same people. The Reid team repeatedly provided Kearney with information, including videos and copies of documents, sometimes with a request, always acceded to. And by the way, I'm told Kearney basically gave Reid editorial control and her team over his content, that he not use it or not use it yet, lest the Commonwealth discern its source. At times, Reid's team would suggest angles for Kearney to cover or otherwise, or ask for his assistance. For example, Murder by Maestro, pay attention, on 8/8/2023, Reid texted Kearney, "Do you have the memo? Town employees," ostensibly from Canton, "were emailed about speaking to you, reporters. Alan wants to blast it." The Reid team responded to Kearney's specific request for information, discussed strategy, and quite frequently stoked Kearney's ego by effusing about his YouTube presentations. Kearney reciprocated by passing along information he has come across, his own theories, and the names of contact information for certain potential witnesses. Both the Reid team and Kearney took pains to conceal their actual relationship. For example, on May 3rd, 2023, Yannetti texted Kearney, "Dude, don't be offended if we don't shake your hand on the way into court. We want to maintain the separation and your independent investigation." And then look what Kearney's saying to Kearney, and look what Yannetti's saying to Kearney in just some of the messages. "That was priceless, dude. Great fucking show. Really enjoy the turtle reporting." Yannetti assured Kearney, "You are a class act. Karen and her parents thank you." That is fucking communication. Karen and her parents thanking you through Yannetti. That is fucking communication between Karen and TurtleBoy. A few weeks later, in June of 2023, Yannetti texted another great article by TB. "You are doing God's work." And then this is the big one, told by Kearney in June of 2023 that on July 25th, Kearney will hold a protest on the courthouse steps where he will have a megaphone this time and make sure hundreds of people are there. Yannetti responded that he loved it. And also, this hearing will be on Court TV, I imagine, and Lawn Crime, and there will be a pool feed. So I don't think for one second people won't pick this up because it's on the Reid docket. So you will be able to watch this on all your traditional channels. I believe Lawn Crime, actually, let me just check for you right now to confirm Lawn Crime will have coverage too. And listen, I like, people were making fun of people with mental illness yesterday, and I just want to say, please don't do that. I would prefer for a number of reasons that you not do that or encourage people to do that. And like, it made me really sad to see people who proclaim to be like supporters of justice for John, making fun of people for their mental illness or using mental illness as an insult. And I don't like that. I want to be very direct with you all. Okay, folks. Okay, I can confirm it. Every channel's carrying it. Law and Crime's got it. Court TV's got it. This is big. They know it's big. They normally don't cover Aidan's hearings unless it's big. This is big. Every channel has it. It's not niche. It's not going to be zoomed. It's going to be with a pool feed on Law and Crime, on Court TV. This is the big one. Yes, Frank's also, let me be frank with you, says he's going to grab the pool feed. Trust me, folks, you won't be able to miss this hearing, because as soon, Murder by Maestro asked if I'm streaming. So normally when there's a pool feed, Murder by Maestro, I'll clip the pool feed. If I can do a live stream, I will get the feed going. But more likely, because it's a pool feed, I will just take clips of the Court TV or Law and Crime feed and then analyze them as they're happening. However, we will do another stream later today once I get lunch, because first of all, I want to say thank you to the folks who have been sending donations. I haven't eaten yet. I have things to do, but I'm going to get food today, and then I'll see you all after the hearing. But no, I have commitments in the morning. And then, as I said, there are lots of people who are going to be streaming, and then I'm checking right now. Law and Crime has it, so you can go to Law and Crime YouTube, just click the videos tab. It's scheduled for 10. Go to Court TV, they'll have it. This is going to be a big hearing. Even though Aidan's going to be on Zoom, every channel will pick it up. We need to get through the rest of the motion, though, because I got to get going. So give me 1 second here, folks. Reloading the full federal court ruling. All right, so whether an acquittal occurred. A verdict of acquittal is final, ending in defendant's jeopardy and barring a subsequent prosecution for the same offense. McElrath. Whether an acquittal has occurred for purposes of the double jeopardy clause is a question of federal, not state law. Under the double jeopardy clause, an acquittal encompasses any ruling that the prosecution's proof is insufficient to establish criminal liability for an offense. An acquittal has occurred if the fact finder acted on its view that the prosecution had failed to prove its case. In deciding whether a defendant was acquitted, we focus on substance over labels and look to whether the ruling's substance relates to the ultimate question of guilt or innocence. In addition to the jury's formal verdict, a ruling that precludes retrial can include, for example, a judge's order granting a motion of acquittal, even if that order is mistaken or based on legal error. Reed argues that there was an acquittal because the ruling here was the jury's unanimous and final decision reflected in the post-trial affidavits that Reed is not guilty. That's not a ruling. She offers no case law that directly supports her argument. Ooh, brutal. Instead, she points to cases where the jury returned a verdict and the verdict form was later amended to fix an error. See U.S. v. Dotson, vacated U.S. v. Stauffer. The Commonwealth counters that there was no valid jury verdict here under mass law. In particular, the Commonwealth emphasizes that under state law, a criminal verdict is effective only when affirmed by jurors in open court. Quoting Reed, the Commonwealth also notes that federal law accords with this principle, Bluford. Here, binding precedent is dispositive. Shout out Bluford. In Bluford v. Arkansas, the Supreme Court considered whether an acquittal had occurred where, before a mistrial was declared, the jury foreperson reported in open court that the jury had voted unanimously against guilt on 2 of 4 charges, but then returned to deliberating. The court held that the defendant was not acquitted on those 2 charges based on the possibility that jurors could have changed their mind during the time that they continued deliberating, but before a mistrial was declared. That's why Reed lost. That case was way worse in terms of the jury actually saying they acquitted on some of the charges in open court. That didn't happen with Reed at all. In other words, even where the jury foreperson had reported in court a unanimous vote to acquit on 2 charges, that was insufficient because deliberations were ongoing and the verdict was not final. Reed's evidence is far weaker than the facts in Bluford. The statements here do not describe when any votes were taken or whether such votes were preliminary or formal. Like Bluford, there is no sign that a final vote was taken, meaning that if any deliberations continued after a vote, jurors could have changed their mind. Nor did the jury announce its verdict in open court. Instead, the only communications the jury made were about its inability to reach a consensus. Therefore, even if we assume that the jury unanimously voted in private that the prosecution had failed to prove its case on counts 1 and 3, the jury did not act on that view. McElrath, quoting Evans, there was simply no act here that could be considered a ruling or characterized as an acquittal. Brutal. Reed requests a post-trial hearing to question the original jurors as to whether they acquitted her on counts 1 and 3 during their deliberations. But on the facts here, we agree with the district court that there was no final ruling of acquittal that would trigger double jeopardy concerns such that post-trial inquiry of jurors would be appropriate. We also share the district court's concerns about conducting such a hearing, which the court said was illegal. Typically, the federal district court. The content of jury deliberations is kept secret to enable jurors to discuss their views freely and frankly and to protect them from harassment. See Tanner v. U.S. Boom. The district court found that these concerns, the freedom of juror deliberations and the protection of jurors against harassment, were unquestionably implicated in this case. That's saying it lightly. We agree with the district court that such a hearing would not be appropriate here. They didn't call it illegal, but they could have. The district court's decision, Judge Saylor's denial of Reed's appeal is affirmed. Reed's motion to stay the state court proceedings pending appeal is denied as moot. Boom, bang, thank you, ma'am. Not a good trip up that First Circuit Court of Appeal for Ms. Reed, I'll tell you what. Is Karen going to be on Zoom? I don't know. Grant, if you got time when it's live, pop into Roberta's chat. Oh, I'll definitely come say hi in Roberta's chat. Angela says, thank you, Towel. Dewdrop says, this is more interesting. Marianne Nunzio says, Grant has to go to school. That's true. I cannot just not go to school. Yes, the butt slap. Will today's hearing be streamed? Yes, it'll be on Law and Crime and Court TV. Yes, Lucy in the Sky with Diamonds. Bada bing, bada boom. Thanks everyone. Cassie, who knows if they may barge in again. Yes, so let's watch. Let's watch the butt slap actually as our closing goodbye here before I take off, because I think the butt slap is just the Yannetti went from sorry for don't take it personal when we don't say hi to you in court. We want to maintain distance to the butt slap. So let's take a look at the butt slap. I know Murder by Maestro likes the butt slap. All right, let's see if I can find this thing here. Hold on, give me 1 second. Is it this one? No. Is it... What I want is... I wonder if we can do this one. Yeah, I think that'll serve our purposes. I think that'll allow us to get to the butt slap video. And once we watch this butt slap, I think you all will get some cathartic relief, because it brings our story like a commodious vicus of recirculation, as if we were traveling through Dublin and its environs on a nice warm spring morning, back to whence from we came. And nicely wraps up this allegorical tale of the rise and fall of human morality as encapsulated in the allegorical manifestations of Karen Reed and Alan Jackson as Sisyphus, Icarus, Pip, Miss Havisham, Irene Adler, Sherlock Holmes, and all sorts of other figures that I just randomly drop in order to make this recursive Vico-style point about the fact that we cannot escape these cycles of human existence. They will come to define us whether we like them or not. Our only hope as humans is to use our cognition to transcend those cycles by coming to understand them and our place within the larger historical synthesis, which is why Hegel's philosophy of history is so beautiful, because it allows us with our words and thoughts, futile though they may be, to express such a non-temporal, grandiose concept as history's intent and thematic mosaic manifestations. We are able to do that by way of understanding ourselves and our role and our short time on this earth in context, and being appreciative for that time on earth and loving those around us and appreciating the friends we made along the way, trying to demonstrate that unconditional love is a virtue and possible, and giving strange soliloquies about the nature of it all while actually scrolling to look for the butt slap video, which is a demonstration of my mind's ability to multitask, because I'm actually looking and paying attention at what I'm scrolling past to look for the butt slap video, but I'm just kind of riffing for you based on what I'm thinking about simultaneously as to the larger historical mosaic that I'm trying to paint with my coverage of the Reed case. So I don't know, welcome into my mind, I suppose. Where is the butt slap? I just want the butt slap. And mind you, the butt slap video, there it is. There it is. There it is.
Prosecutors weren't out. The Commonwealth, the prosecutors weren't outside patting their bloggers on the butt for a job well done after witnesses were harassed at the family events. That didn't happen.
Butt slap. Oh, wait, hold on.
The Commonwealth, the prosecutors weren't outside patting their blood.
Let's watch the butt slap. There it is. One more time for the historical record. I know you enjoyed it, Murdered by Maestro. I know the butt slap video is your favorite. I hope we all had a great morning. I must get going, though. I have things to do. I will be back with you. We will do our analysis. Thank you so much to everyone who supported the stream. If you do want to send a donation, today's a good day. I got to get some lunch after class. I would like to get some more of my medication. I will then come home. I will sit with you. I will drink some kind of energy drink, and we will talk about what happens at the hearing. However it plays out, I'll do an analysis for you, give you some predictions going into next week. We'll monitor the Reed trial docket to keep an eye on whether there are any updated rulings on the 23 or so outstanding motions in limine heading into the trial. And then, of course, we'll monitor the docket to see what, if any, filings go up from the state or the defense in the Reed case. My name's GrantSmithEllis. I'm a towel. Thanks very much for being with me. I'm sorry I have to leave you so soon, but as many people have said, and as the wonderful moderators have been reiterating, it is important for Towel to adhere to his commitments. But yes, God bless, folks. Enjoy the rest of your morning. We will see each other. This is a rare moment. We will see each other again today, probably in a few hours. God bless. Be well. Reach out if you have anything going on. And thanks very much for being with me. I really appreciate it. All right, folks. See you soon.